The read appeal matter only consideration by Lord Mayor. Previous direction was the remand order was passed.
You are making a mention.
No, madam.
Which
The
item
item
number
number
three?
1.
Yes.
Item number 1, madam, kindly come to page
Item
2.2,
number 1.
page 15. madam.
Just a minute.
Madam.
Just- You want us to see page 2,
Page 15, madam. Para 2.2.
page 15.
It was a wrong judgment. It was a wrong, long judgment, madam. I'm sorry, long judgment. But kindly see para 2.2, madam. One aspect, madam, was lost sight of by the honorable judge. Honorable single judgment. Page 2. Para 2.2, madam. The
You are-
ADM passed that order, madam, on the matter being remanded by this honorable court.
Paragraph 2.
2.2, madam. Page
Yes.
15, madam.
Yes.
Here, madam, responded.
This is
Which
an
resulted
writ appeal.
dismissal of.
This is in writ appeal.
Yes. I understand, madam. I understand my limitations
Ah.
also. Only
No, no.
one thing, madam, when the matter was remanded by the additional
No,
ADM, madam.
you seem to propose that I have lost sight of.
No.
Ah.
The honorable single judgment.
But it is writ appeal.
No,
I have taken note of this.
I'm just indicating to Lordship. When the first round of litigation was remanded for the ADM to decide, the specific remand order was passed on the ground that the service area was not demarcated before the selection could be taken. On that basis, madam, if you also look at the judgment, this aspect, madam, I could not have brought to your Lordship's notice. Otherwise, my lord, the order would have been the same. But the last line, my lord, while remanding the matter, he has said respond number 5, meaning thereby the writ appellant is not entitled to be considered. If there is a remand, my lord, let my case be also be considered. If you also kindly see the earlier judgment.
Let us see the direction first.
Well-
The direction.
My lord, the honorable single judge order, my lord has quoted page 17. My lord has quoted, my lord, each and every order.
Page.
Page 17. In the first paragraph, my lord, in the middle, in the result, 10 lines from the top, my lord, in the result.
No, which page you are reading?
Page 17, my lord, 17.
17 of what?
Of this application, my lord, the review application.
Nee, what for?
The direction was by the ADM, my lord, to he has set aside the appointment order of the appellant, remitted the matter back, my lord, to be considered by the selection committee afresh, with a stipulation that keeping in view that respondent 5 is held to be not eligible for consideration, not a resident of the area.
Respondent number 5 is
Yes.
not, you are respondent number 5.
Yes, madam.
Respondent number 5 not eligible.
Not eligible, not coming within the residence of that area, madam.
This
Submission.
finding,
Yes,
this finding is incorrect.
yes, please.
This finding has been approved by the learned single judge.
Not single judge, madam. And by the honorable division bench.
All right. So what is wrong in that?
Wrong, my lord. If you also look at the first order, remand order, there is a direction that the service area has not been demarcated. That is why, my lord, the remand order was passed by the first honorable single judge, my lord, in the first round. So the direction was you consider this, then consider the application. But in the present case, my lord, he has directed the respondent 5 is not eligible. Keeping in my lord, can you see the order?
Not eligible only after demarcation.
Yes, well, only that part, because the order which has been confirmed by the honorable division bench, my lord. As if, my lord, the respondent number 5 was not a resident, he has to keep in mind that the selection committee is bound by this observation, my lord.
What is that? What is that?
Page 17, my lord. Page 17 of the review application. In the middle, my lord, 10 lines from the top. In the result.
10 lines from the top.
Yes, madam. Page 17.
Yes.
In the result.
Yes.
In the
In the
result.
result.
In the result.
In the result.
Yes.
In the result, the prayer of the appellant is accepted. Engagement of respondent 5 as the Anganwadi worker of Dalal Anganwadi Center is set aside. Matter is remanded to the selection committee to dispose the matter afresh, keeping in mind the findings that the respondent 5 was not a resident of Dalal Anganwadi Center. My question, my lord, if I would have brought that notice to my lord, that about the earlier judgment of the court. The specific remand was set aside, my lord, on the ground that the demarcation was not made with reference to the service area. Only, my lord, this aspect will go.
But why should we review?
Lord, your lordship's judgment, my lord, confirmed the honor single judge order.
There you could, if that is so, you can go before the. Very difficult. You could not brought that to the notice of the court. That was within your knowledge.
But kindly see the earlier judgment of the court while remanding the matter to ADM.
Where is that?
But I have given a copy.
No, where is the order of remand? Where is the order passed by the ADM?
ADM, my lord, that portion is quoted, my lord, page 76. 76. Page 76, annexure 6.
Page 76.
Yes. It starts from 76.
Yes.
In the paragraph, page 78, my lord. Last paragraph is the finding.
Yes.
Having heard both the parties to dispute and going through the evidence and record, I was of the opinion that the college road extends from so-and-so police station. The residence located on either side of the aforesaid road was called residence of College Road. Different sahis originated from College Road and extended different directions away from the College Road. It is seen that between Gaud Sahi and Nityan Sahi, there is another Sahi called Gupta Gaud Sahi. The Nityan Sahi is neither.
This is the order passed by the appellate court, by the ADM.
By the ADM.
The ADM says that you are not the resident of that area.
Right.
That finding has been approved by the learned single judge.
Right.
That finding of the learned single judge has been approved by the division bench.
Right.
Now, what do you want to say?
Only, my lord, if the earlier judgment of this honorable court, my lord, directing a remand.
Which judgment?
The judgment, my lord, given.
Huh?
That judgment I have given, my lord, 2 copies. But this was the first order, my lord, where the matter was remitted back.
Now to the, this, yes. Yes,
Can you come to page 6? Page 6 of the judgment.
Yes.
It starts from page 5. Second paragraph, third paragraph. Now it's a fact case. It is admitted that the center has.
See, we can consider your review application, but you will have to pay heavy cost. We don't know. This is not how the court proceedings are taken.
I'm sorry. Well, I leave it to
ADM passed some order. Some order was passed in 2016. Thereafter, ADM passed some order. ADM's order has been affirmed by the learned single judge. That finding has been affirmed by the division bench. Now you are saying you are taking us back to 2016 and saying that ADM's order was illegal. Therefore, order passed by the learned single judge was also illegal. And therefore, the division bench is we will entertain, but we are subject to payment of cost, exemplary. There must be an end. Otherwise, next time you may come with another review application that in the particular sentence there is a grammatical error. There is a grammatical error, and that grammatical error is being misconstrued. This is not how the court proceedings are taken. Sort on. Dismissed.
I want one opportunity, my lord, in the selection process. My application was there, my lord. That I will permitted me to raise that before the selection committee.
For orders item number 2.
Yes.
Dismiss for default, limitation the notice to go up or open over 4 and 5,
What is the limitation?
97 days.
97 days. So what was dismissed?
On decision honorable that honorable Supreme Court there are two judgments.
Huh.
In one judgment that she said that before taking conscience of a case of a terminated person, the appointment, the person who has
petition was
appointed on against him should be given an opportunity here, man.
Your writ petition was dismissed. Or
My
appeal was dismissed. You have filed restoration or for what? Restoration of what?
Restoration of writ appeal, my lord.
Issue notice. Issue notice.
4 and 5, my lord. 1, 2, 3, I must serve copy, my lord, to the government.
1, 2, 3. Just the one so. Accept notice.
4 and 5, my lord.
Issue notice 4 and 5.
Resti post to that.
Limitation and the main matter both. That will expedite because there are restoration matters. Restoration we should be given.
Item number 3.
In both, my lord. IA as well as writ appeal.
Lordship, item number 3 kindly taken up next week, Lordship. Petitioner engaged Mr. B.K. Mahdi. He is suffering from cardiac disease today, Lordship.
He is suffering from cardiac disease today,
Lordship.
but this is 2014 matter.
Lordship, kindly taken up next week. We make alternative arrangement, Lordship.
Friday, can we fix it on Friday?
Lordship.
Huh? Friday?
Lordship.
This Friday.
This Friday, Lordship.
This Friday.
Lordship, kindly taken up next Friday, Lordship.
See, constitution of these benches, it's very difficult.
Lordship.
So if you decide the dates, then
Lordship, this Friday.
Friday. Yes. Does this matter on Friday? Yes. As it was.
Is the part of the judgment, your lordship. Review petition. Review petition. My ladyship is.
Give all these such slips to the registrar judicial. I am planning to list all these matters on Fridays. All right.
My lord.
Which are tied up matters. All those matters shall be listed on Friday. Just give the slip to the registrar judicial. He is preparing list of such cases.
Deep level.
All right, and I am monitoring that.
Mild.
Criminal appeal matter, my lord, second round. Earlier rejected Honorable Justice D. Das and Honorable Justice G. Satpat, my lord. This is the break bench
Same.
matter, my lord.
Same. Just give the slip to the registrar.
Pardon, Your Lordship, my
Judicial, Deputy Registrar Judicial.
Obliged.
All
Pardon,
right,
Your Lordship,
Deputy
my lord.
Registrar Judicial.
I filed a memo for admission of a writ appeal. Can it be restored in a convenient day?
What is the urgency? What is the urgency?
Then say they are going to break my house.
Break your house, why?
They have said any day they may break. I have.
Why?
Because
Why should your house remain?
this construction is not in accordance with the approval.
Then
But
this
this
is-
construction is a very old construction.
Therefore, our question was, why
Very-
should your house remain?
This is a very, very old construction.
Maybe, but contrary to the bylaw.
It is not condemned. I have applied for approval under the rules. I have applied for.
Yes, the application is not enough. We will take up. We will
My
take
lord,
up.
I beg pardon to mention, my lord.
इसको लगाना.
My lord, I beg pardon.
Your Lordships,
My lord, criminal appeal of 2021. Previously held by my lord, Chair Das and my lord.
Give this slip to the Deputy Registrar Judicial. All right.
Milord,
All such slips.
Milords here, it's a tender matter, Milords. My
तो एक notice निकलवाते ना वो kind of matters है. It should be all such slips should be placed before the Joint Registrar Judicial. No requirement of it.
The pardon
No, this-
mention the modification of the lordship.
See, when so many lawyers are coming for mentioning, there should be one system that if a senior advocate is standing, he or she should be given preference. Everyone should, that culture, if it is there, it's all right.
Yes.
So it's not, should be there. Yes.
Your Lordships, in the last Thursday, I had mentioned this matter. Your Lordships have told me to mention it's at serial number 49. If it can come first week of August at 2 p.m. It's a mining matter, Your Lordships.
First off,
First week of August. I'm proposing 6th of August.
but why not today?
Your Lordships, I think may not reach, and there are two more matters also which is fixed today. So only, I mean, in fact, last time I mentioned, and Your Lordships have told me to mention it again, so the date can be fixed. I'm just proposing 6th of August, and I think the arguing counsel from the government side is also not present today. Mr. Mahanti is not. That's why I'm proposing if 6th of August at 2 p.m. it can come. There's some urgency in the matter.
This was कुछ है क्या? Well,
Obliged.
we are not averse to taking up long matters in the first half also. If the matter is urgent, we have a
Yeah, no, I
responsibility.
fresh admission matter, so I thought I'll
All right.
occupy the court at 2
All right.
p.m.
Only. Yes,
Modification of the lordship order.
ले लो modification.
Tomorrow. To start tomorrow.
But me sitting with whom? Sitting with Mr.
And this on all bench.
This is the tender matter, Milords. They are going for encashing my bank guarantee by saying that I've suppressed materials. There is no suppression. I mean, the material was before them. I had told them that this is the fact, and they are now going for encashing my bank guarantee. Milords, this is an urgent matter. Milords may be listed tomorrow.
How is that urgent?
Milords, what has happened, Milords? I was working under NHIDCL.
That understand, that
Yes.
we understand, but how is that is
If
it
they
so
encash,
urgent?
Milords, I'm a MSME, Milords. If they encash my bank guarantee of 80 lakhs, Milords, I'll be nowhere. That is the all prayer, Milords.
Not tomorrow, I will see.
Milords, urgency is there. They have issued letter to the bank.
sir.
That's the only problem.
It's a read appeal ballots, when he has challenged the order passed with the honorable single judge, when he has rejected the prayer of the petitioner for regulation. When the honorable single judge has rejected the prayer of the petitioners for regulation despite working for 20 years in a vacant post minutes. The prayer of the writ application has been rejected. It's a read appeal. I pray this matter to be taken up tomorrow because they are taking steps now that the petition has been dismissed. They are taking steps for
Where is the
termination.
question of this? We can take up the matter today. Why tomorrow?
Well, they're taking steps for termination, my lord. Since my application has been rejected, my lord, they
No,
are taking.
suppose your termination order is held to be illegal,
My lord.
then you will get everything.
Yes, ma'am. But
Why is so urgent?
because my lord, the regulation, I think, means regulation if termination is there, the proprietary method
Regularization,
that should be in
it's
service.
difficult, Mr.
I'll take it up tomorrow.
Regularization, you have a different law here. All right.
Means will satisfy. Means will satisfy your lordship tomorrow.
We'll see.
Tomorrow,
Seriously.
tomorrow, ma'am.
Not tomorrow.
My lord, pardon to make a mention, my lords. My lords, this is a tender matter, my lords.
But is this a fresh matter?
It's a fresh matter, madam.
Fresh matter, why are not coming? ऐसा करो.
Kindly take note. Only request to.
Yes.
My lords, is a tender matter after notice matter, my lords. It is already admitted and notice has been sent since 21/11/2023.
All right.
My lords, now no counter affidavit has been filed yet. So no, they are taking steps so
So
to
in
be
fact,
urgent.
give who is appearing for the other side?
State of
Who,
state.
do you have any idea? Give that slip to one of the council representing the estate. Make a mention after, say, next Monday. All right.
Okay.
So in the meanwhile, they may decide to file counter affidavit. So that whenever your matter is taken up, that can be decided on merits.
My lords.
All right.
Pardon to mention, my lord.
If no counter affidavit has been filed, they will be filing counter affidavit.
Pardon to mention like that.
Yes.
This tender matter, Lordship, last Monday I have mentioned. Lordship had to ask me to wait and mention this week.
What is that matter?
That tender matter, madam.
Tender? Or tender for?
For construction of proposed Ellis Bridge.
Fresh admission?
My lord.
That's admission matters.
No, we had mentioned last week. Mentioned.
Little, but.
Oh, bless me.
Right, those.
Lordship have granted liberty me to make a mention in the morning that blacklisting matter, your lordship have granted. Your lordship, I know
Which
your
item is this?
61, your lordship.
61.
Very
When was the blacklisting order?
Milord, blacklisting order was passed, Milord, February 2000, Milord, Milord, this year, your lordship.
This year?
Your lordship.
Then it is not
Yes.
that.
Milord, the no show cause, your lordship, every single show cause notice. Milord, I mean, society
Whether
100.
counter affidavit has been
Yes,
filed?
pleading, yes, all pleadings has been completed, Milord.
Everything has been filed.
Subject to your lordship, I know your
We'll take
lordship,
up your matter.
your lordship.
We'll take up your matter tomorrow at 4.
Yes, your lordship, obliged.
Tomorrow, 4 p.m.
Tomorrow at 4 p.m.
Yes.
we will take up.
I look.
And do you have any appellate authority under which provision
Milord, their PWD contractor registration rules, Milord. But there is a contract license procedure, they have license, and the OPWD code, they are blacklisting. There is no appeal provisions.
so those rules, whether they have statutory force?
No, it is a executive instruction, Milord. And even there is a several lots of that no so cause contemplated so cause is they have not even only action taken. Lots of that.
Is this happening? This should not happen.
My lord, item 73 on your lordship's list today. Item 73, my lord. Your lordship recollects this is the neat matter I had mentioned last Thursday, my lord. Lord, may I only seek your lordship's indulgence to take the matter only up for 10 minutes today, anytime in the afternoon, my lord, subject to your lordship
So
convenience.
what happened? Whether any affidavit has been?
Yes, affidavit has been filed, my lord, and I'm grateful, my lord, that the affidavit comes to my aid, my lord. They state in the affidavit that I had raised the objection and the expert committee rejected my objection, my lord, for both the questions. This was the identical argument yesterday in the Honorable Apex Court, my lord, wherein the Honorable Apex Court has mentioned, has directed that the physics question goes to the IIT committee. I'm seeking the same direction from your lordship because
The Supreme Court has.
my lord, the botany question is not before the Apex Court, my lord. And this was the last observation before the Apex Court that
We may decline.
I'm obliged, my lordship, only hear me, my lord, on that.
We may decline. We see. If there is no, if we start doing this, there will be no end to expert committees.
My lord, the expert committee is sitting today, my
All right.
lord. My lord, in the afternoon today, my lord, any time subject to your lordship's convenience.
We'll take up your matter.
I'm obliged.
We'll take up your matter if the in the second half.
My lord, I'm obliged.
And who is the
My lord, Mr. Bhokta had informed him already. He's the Central Government
informed.
Council. I have informed him already.
Second half we will take up.
My lord, I'm deeply obliged.
4.
4 o'clock, deeply obliged.
Supplementary list item number 1.
My lord, next time your lordship directed to.
This case, lordship said directed to file an objection in consonance with lords section 389(1) proviso, my lords. I would ask the my lords IAC Telkoi police station because under his jurisdiction, my lords, this my lords, PS case arises, my lords. In fact, only 2 days back the new income joined. He is sought for 2 days time. May premium lordship take it up on Wednesday so that he can.
11 years, 9 months in jail.
That I know. We don't have an objection for being released. Only question is compliance of
custody. Since when you are in custody?
Yes, my lord, custody, my lord, since 11 October 2012, lordships.
IA number 1010 of 2024. Present application has been filed on behalf of the sole appellant,
My lord.
sole appellant for
So
suspension.
there are 4 appellants. I think somebody will be released on bail. The application to 1 lord.
Number 1.
4
This is
appellants are
one.
there.
In this, there is only one appellant.
Yeah, because others have been released on bail earlier, my lord.
Who are released, my lord, or the.
And this is for 1 only.
One only, yes.
For the appellant Lochan Panthei.
Yes, sir.
Lochan Panthei,
Yes, my lord.
you are seeking bail for
Bail,
Lochan
bail.
Panthei.
Or bail, my lord.
Are we asking the name of the petitioner?
Yes. Lochole Penthayman.
His appellant number?
1.
Yes.
Lochan Panthei, who stands convicted of the offence punishable under section 449, 302, 34 of the IPC. Read with 34 of the IPC and sentenced to imprisonment for life with fine. Full stop. Next, when counsel appearing on behalf of the appellant has submitted that the appellant has remained in custody continuously since 11/10/2012, and there is no likelihood of this appeal being taken up in recent near future. Stop. Next, solely on the ground that the appellant so and so has remained in custody for nearly 12 years. And in the given situation, the appeal may not be taken up for final hearing in near future, comma, this application is allowed. Full stop. Let the appellant so and so be released till the sentence shall remain suspended in meanwhile. Okay. We, despite opportunity granted to the state to file an objection under section 389, under the 389(1) of the CRPC, no such no objection has been filed. Oh, sorry. We have heard. Yes.
Item number 2. Here also lawsuit directed me to obtain instruction from the appellant, that is the DA for Satkosia, with regard to the application submitted under section 26 capital A of the Wildlife Protection Act before the central government. In the morning, he telephoned me, he stated that he is trying to get it, he could not trace out the record.
Contempt case.
No, here my review application is pending. That's why Lordship wanted to know dispose of the review first, so that if my review goes, we will comply the order. There was a direction to allow his land, trees on his land to be cut and 22 of the.
So let us see what is the review. We can hear the review application.
Plus, only review. The only question is that his land. Our plea was that his land comes within the territory of Satkosia,
Reserved forest.
Reserve forest. So an application was filed before the central government under section 26 capital A of the Wildlife Protection Act since long. So Lordship last occasion wanted to know what is this the status of that application filed by the state government. If it has been allowed, then here no case. If it has not been taken up, then his earlier order passed to allow him to cut the trees from his own land. That has to be complied with. And the DF I have talked to, he has only paid for 2 days time. He said that if he can take it up on Thursday, he can say what is the status of that 26A application.
2 days maybe.
I have been on behalf of the containers. This case on Thursday.
Case admission item number 3. So item number 3. So now the order of lawsuit has to comply with, because the affidavit the SLP filed before the Supreme Court has been dismissed in May. Now the officer, because it's an R&R benefit, the director has been requested to comply with the letter number. So he has prayed for 2 weeks time to get it complied with.
So we are in August. Your contempt petition, your SLP was dismissed in May.
Yeah.
So you will have to explain this.
I filed an affidavit today seeking for time. I've got the hard copy. The director has requested to comply the order of lawsuit immediately.
So where was the direction? Where was the requirement of any direction? The moment the SLP was
No, that is
required to
no.
comply.
Here I have only prayed for extension of time. I filed an IA for extension of time.
Where is the IA?
It has not been listed. I filed already.
It is stated by Lund AGA representing the contemners that an application has been filed for extension of time for compliance of this court's order, violation of which has been alleged in the present contempt application. So this said application is not there on record. List this matter on 2 weeks.
Yeah.
With the said application on record.
Yes. I'll see that in the meantime. It is done.
Get the hint.
Yes. Item number 4.
My lords, on 25/6/24, my lord directed that the matter be taken up for admission, and at that stage, my lords will consider the period of limitation. Now, my lord.
Long delay of 250 days. There is long delay of 250 days and no explanation whatsoever has been given in the petition.
250.
250 days. And no explanation saying that only we got the order on such and such date. We sent it for legal opinion to the law department for such and such date. And then that entire period is obtaining the permission from the law department.
So we are ready to pay.
No other, no
we
other.
we are ready to ask them to pay some money to you for delay. That can be recovered from. That amount can be recovered from the officer concerned. The state's interest cannot be, it is not the state's interest, it is the interest of the society. So the state, see, if a clerk, no, that is not the question. If a clerk, because of the failure on the part of a clerk or of the officer, an appeal cannot be filed, appeal could not be filed, then the cause cannot be defeated on that ground, because that cause is not of that officer, that is of the whole society.
That also they don't
That-
say. They
All
only
right,
one
forget
line.
that.
Only
Forget
one
that.
line there. That
Forget-
we sent it for legal opinion from the law department such and such date.
That is what we are saying for this negligence. If otherwise the order is illegal, we cannot ignore that. That is what we are saying. That is why we have said put it for admission.
Let us consider both, and we can condone the delay if you agree, subject to payment of exemplary cost.
I will accept this. I will accept this.
So we normally direct 100 rupees per day. If there is no explanation, if there is some explanation, then it's a different matter. According to you, there is no
No,
explanation.
I'll place it.
Then 100, no, all right. You say you have said we believe it. Why should we see the application? This much confidence we must have in you. So you say there is no explanation, we accept there is no explanation, 25,000 will be.
Malord will hear me on merit.
Yes, we are hearing on that.
Malord, on 10/2/2009, this writ petitioner was appointed as a contractual staff nurse.
10/2/2009.
I will only give 5 or 6 dates to my lords.
10/2/2009. 2009.
She was appointed as a contractual staff nurse.
Contractual staff nurse. Then
And she joined on 19/2/2009.
yes, 2009.
My lord, this is appointment.
10/2/2009.
The order of appointment issued. She joins on 19/2.
Yes.
My lord. Then while in contractual service, she was selected to go for MSc nursing training.
Yes.
She was relieved. She completed the course. While she was doing the course, not completed, she was regularized. The regularization order comes on 27/7/2017. I will take my lord to those annexures. Only I am
8
giving the
years
dates.
after.
My lord?
8 years after.
Yes, ma'am. She was regularized with effect from 2015. But the order of regulation comes on 27/7/2015. Now,
15 or 17?
27/7/2017, I'm sorry. Now she makes an application. She comes to this honorable court. This honorable court was pleased to grant an interim order by virtue of which she was sent for training. She was initially not being sent. By virtue of my lord's interim order, she was sent for training. She completed that. After that, the writ petition was dismissed. But she completed her course and she prayed for the period of training to be treated as duty. Salary and everything. We said your period of training shall be extraordinary leave. That was the subject matter of challenge before the Honorable Single Judge. And the order of that Honorable Single Judge is we have assailed, my lord. Now, may I take, my lord? My lords have the counter I have filed. I will show, my lords, only 3-4 documents. May I take, my lord, to annexure B of my counter, please?
The writ petition.
of the counter to the writ petition.
Yes.
My lord sahib.
Yes.
Annexure B, my lord. My lord, may kindly see. This is the order on 6/11/2015. Now this reads, I am to enclose here with the list of candidates admitted into post-basic BSc nursing and MSc nursing course at Government College of Nursing, Berhampur, against 85% government quota seats in private nursing colleges in the state during the academic session 15-16. The above admission have been considered on the basis of NOC issued by the competent authority in their favor. This is on 6/11/2015, my lord. Now, my lord, may kindly turn to the next page. My lord will find the name of the petitioner, writ petitioner at serial number 5.
Yeah.
I will not take my lord to annexure C at present. My lord may kindly skip over and come to page 14 at annexure D. Now, this is a very vital document. I will pray my lords to kindly look at it. Annexure D. May I place it, my lord?
Yes.
In pursuance of letter number such and such of the Director Nursing Odisha Bhubaneswar, Srimati Devika Mishra, that is the writ petitioner, my lord. Staff nurse contractual of this hospital is hereby relieved on 17/11/2015 in order to enable her to enabling her to report before the Principal College of Nursing, Berhampur on 17/11/15 for prosecuting 2 years MSc nursing course during the academic session 15-17 at her own cost by availing leave due as admissible. Now, this was on 16/11/2015, ma'am. Madam, kindly see. She completes the course. She is relieved on 27/7/2017. The next order, my lord, may kindly see annexure E, page 15.
Yes.
Government of Odisha, the following contractual staff nurse of this establishment are hereby appointed as regular staff nurse in the scale of pay of such and such with usual allowance as admissible thereon from time to time from dates as noted as rendered 6 years of qualifying contractual service. Now, I have already pointed out, my lord, she was appointed in 2009. She completes 6 years, 15. My lord, kindly see now. First is writ petitioner, Srimati Devika Mishra. She completes 18 to 2015. She was regularized from that date. Now she makes a repentation and my lord may kindly come to page 19, annexure H. The recommendation is made by the departmental authority because she was claiming for duty. Now, my lord will see 4 persons. All they were the persons who were sent on training, similarly placed. They were recommended. And the next page, my lord, may kindly see page 20, the decision taken. My lord, I'm sorry. The next page 21. Page 20, my lord. That will be page 20. I'm sorry. Page 20. The study leave period is granted in favor of Srimati Devika Mishra, writ petitioner, staff nurse, with effect from the date as mentioned against her name under Odisha Leave Rules 1966. Devika Mishra 17/11/15 to 16/11/2007 treated as EO extraordinary leave. Now, this order was challenged. And this honorable court, my lords, the next documents are all these persons who were sent for training, all their periods have been treated as extraordinary leave. Now, this honorable court in the writ petition, somehow, my lord, observed now, my lord, may I take my lord to page 22 of the judgment. I will start reading from para 6, my lord, that starts at page 21.
Page 21
Page 21 of the writ appeal, my lord.
of the writ appeal.
My lord. Internal page 7 of the judgment.
ସେ କବାଟଟା ହଉଛି ତାହେଲେ କବାଟ ହଉଛି
Cover tower.
Yes.
Para 6 I am reading, ma'am. Considering the contentions raised by the learned
Just a
counsel.
minute, just a
Ma'am. Page 21, ma'am.
yes.
Para 6 I am reading, ma'am. Considering the contentions raised by the learned counsel appearing for the parties and after going through the materials available on record, this court finds that the petitioner was engaged as contractual staff nurse by order dated 10/2009 issued by the superintendent MKCG Medical College and Hospital, Bahrampur, with consolidated salary of rupees 4,500 and special allowance of rupees 1,500 per month, pursuant to which he joined as a contractual staff nurse on 19/2009. On 18/2015, she completed her 6 years of contractual service in view of the GA Department resolution dated 17/9/2013, published in Odisha Gazette dated 18/9/2013. Her name was recommended by the Director of Nursing Odisha by letter dated 3/8/2015 to the State Government for Regulation of Service. My lord, there. May I take my lord to
Yes.
page 25, paragraph 8. My lord, page 25.
Yes.
My lord. Otherwise also, by virtue of notification dated 25/8/20, this I will show again now, my lords. Otherwise also by virtue of notification dated 25/8/20 under Annexure 12 issued by the Government of Odisha Health and Family Welfare Department, the contractual service period of the petitioner shall have to be treated as government service for the purpose of computation of 5 years of regular service under Rule 180 of OCS rules for grant of study leave in our favor. Therefore, even though the petitioner joined as contractual staff nurse on 19/2009, on completion of her 6 years of contractual service on 18/2015, her service has been regularized. Applying the notification dated 25/8/20 to the case of the petitioner, she should not have been denied the benefit of regular pay and allowances as due and admissible to her during the period she was prosecuting her higher study. My lord, as I read paragraph 8, may I take my lords back to page 25 again, please.
Yes.
My lord, I am reading from top, my lord. Page 25, reading from the top. As a consequence thereof, she prosecuted her higher study. My lords got it? She prosecuted her higher study and also came out successful. In the meantime, her service was regularized. Therefore, impugned action of opposite part number 2 treating the petitioner differently than other similarly situated persons is discriminatory and violative of Article 14 of the Constitution of India. In the facts and circumstances of the present case, treating the period during which the petitioner was prosecuting her higher study as extraordinary leave has no nexus. Rather, the same should have been treated as study leave, entitling the petitioner to get pay and allowance as due and admissible to her at par with regular employees of the establishment, particularly when such benefit has been extended to similarly situated persons. This, in my most humble submission, my lord, this is not correct, my lord. So the only thing, my lord, that now I am to show, my lords, a notification dated 25/8/20 on which this honorable court has relied upon and has said that yes, by virtue of this 25/8/2020 notification, she should have been entitled to. May I take my lords to that notification right now? 25/8/2020 notification is, my lords, may kindly refer to the writ petition now. My lord, to the
No, but one thing is not clear.
No.
She was appointed in 2009.
Yes.
Her services have been regularized with effect from 2015.
Yes.
So she is demanding what from 2015 to 2017 or 2009 to 2017?
2015 to 17, the period of MSc training she took. She is saying, treat it as study leave and give me pay and allowances.
So this benefit was not given to others.
No, my lord. It was not given to others, any others. This is my specific case before my lord. That
Was she was sent by you.
yes, ma'am.
She was sent by you for this training. And why not study leave, paid study leave?
Because my lord, by that time she was not a regular staff.
By that time, but in 2015, she became regular staff.
Later,
Later.
my lord.
So once later, you give that with retrospective effect.
Right, ma'am. Now my lord knows if I'm a regular staff, unless I have 5 years of service minimum to my credit, I can't be sent for study leave.
No, but see, suppose you grant her regular appointment with effect from 2009. So she is a regular staff from 2009.
Yes.
So this is what you have done.
No,
So you can deny from 2009 to 2015, it's a different matter. But from 2015 to 2017, how can you deny? You had sponsored, you had sent.
my lord, probably I'm not.
Let us see. Yes, what is the rule?
My lord, may kindly see.
No, for sending for the higher studies, she needs to have worked for 5 years.
Yes.
Oh, so when she went in 2017, she can take it for 2
She
years.
had only 8 months. Even if my lords will consider the retrospective order, giving effect from
15,
so she had only 5 months amount.
2 years, 2 years.
No, where is that?
Regular service.
Where is that?
Regular service.
Regular service you are given from effect from 2015.
From 15, she was sent for training in 2015 only.
Saying that 5 years from 2015.
Oh, she went in 16. Okay.
No, in 15 itself.
Oh, she went in 15
Yes.
itself. Okay.
2015. Let us see where is that.
So even if regularized, she had not put in 5 years. Okay.
Rule 180.
My lord.
That is the rule which has been referred to.
My lord. That is also, my lord, I will at page 24 of the counter.
That is quoted.
My lord, it's there. I have annexed it.
No. This the Orissa Service Code. OCS rules.
The service code, my lord. That is
Civil service rules. What is this OCS rules? OCS.
no, that is OCS that wrongly written. Orissa Civil Services rules, my lord. That is 179 of the service code, my lord. Okay.
Service code. It must be service code.
Panta.
No, this 180. See, that is ordinarily.
My lord.
That is ordinarily one. And two, it was not that she had applied for a study leave.
She had applied. She had applied. We selected her, no doubt. She had applied. But question is, my lord, when we, on the basis of this, and we have given a similar treatment to all, and while leaving, we say that yes, it will be leave against leave. She doesn't challenge that. Having come down, thereafter she completes the training. Can it be?
Where is her application?
My lord, the application she has not annexed in the writ petition, but she has stated that she has applied.
Where is that?
May I take my lord to the writ petition now?
Yeah.
Page 4, 6.
My lord, page 4, paragraph 6F.
F.
Paragraph 6.
6F. Page 4 of this OA. That's writ petition, my lord. WPC OSC.
Oh, no, you're reading more.
We see.
Hmm.
Internal page 4. Our running page will be
Internal page 4. All right.
6F.
6F. Six F.
Yes.
Now,
So 6F is seeking study leave only from 15 to 17. Not for the previous, for the earlier period.
this is the dispute, my lord. Only
That
dispute
is
is for the study leave period. Now, my lord may ask me why all this dispute. Now, my lord, normally we never send a contractual person for training, for higher training.
Oh.
Let me complete, my lord. So you were not sending her. Now she comes to this honorable court. Now, in Annexure C, now my lord will see
All
that.
right, where is her application? This
That
6F?
application she has not annexed, my lord. If my lord will direct me, I will produce that application.
That may be there in the other writ application.
No, that she has not given.
Other writ application which she had filed for being sent for training.
Yes, yes.
So
Might.
2 writ applications are filed.
Yes.
As
one
my
was
lord
for
is
sending
looking
for
at
training.
now writ petition, my lord may now please may kindly come to the counter at Annexure C. Why, how she was sent for training? Annexure C will, my lord will find at page 13. Now, this order, my lord, 26/10/2015, because of this order, she was sent for training. Otherwise, you would not have sent her on training, ma'am.
Interim order passed by this.
Because
court.
by then, my lord will appreciate, we had not regularized her. Now, this writ petition gets dismissed ultimately. So,
Might have been dismissed because it has become infructuous.
my lord, she said it has become infructuous because she has got the training and submits to the court that it is infructuous. So she has to now accept it, my lord. Now she must accept that she, because of this interim order, she got the training. And now coming back and asking, seeking duty as a study leave, full pay.
So what for this writ petition filed?
Because, my lord, we are not sending her.
No, the earlier writ petition was filed because you were not sending her
Yes.
because she was not, had not.
You
was
have
not
stated
accompanied.
all these facts in the counter affidavit.
In the counter, yes, my lord.
Where is that?
So,
So that annexure D, where names of others are also mentioned, that means they also have not been granted the same
No.
benefit.
my lord, may I read para 2 of my page 2, the last paragraph of my counter. The petitioner obtained the required NOC, no objection certificate from the Superintendent MKCG MCH Barampur as per the interim order number 2, dated 26/10/15, passed by the Honorable High Court of Orissa in WPC number such and such. Since she had completed 6 years of contractual service, but her service was not regularized by government at the time of her selection for undergoing MSc nursing course. It is submitted that the petition was relieved by the order dated 16/11/15 of the Superintendent MKCG Berhampur to join MSc nursing course for the academic session 15-17 at her own cost by availing leave due as admissible as per rules in vogue at that time. She had not completed 5 years of government service before undergoing above training course. That was our stand all along.
So that is not mandatory.
Well, right
That
or wrong, we
requirement
have
is
taken a
not-
stand and we have maintained it for all, man.
Maybe,
Well-
that is not mandatory. The only question is effect of dismissal of the writ petition on the ground that that had become infractuous.
Yes. This honorable court has not
What is the NOC?
settled that, yes, she has the right.
Who gives the NOC?
My lord, because the NOC is to be given from where she is working. We gave the NOC because this honorable court directed. This is my case. We have not granted anybody, similar person, anybody you have not granted. So that a submission to this effect, my lord, with great respect, I will say it was misleading.
Just a minute, Mr. Mishra. In your counter affidavit, you have stated that while disposing it off as infractuous, this court has directed that if she has any grievance relating to counting of the period of study leave, she is at liberty to approach before the authority, and if it is admissible, the authority shall take the decision in accordance with law.
My lord.
This court has not expressed any opinion on the merit of the case. Okay. And it is up to the authority to take the decision on its own.
So we took the decision on 4/9/18, declined, as you have declined to all others.
Yes, that's sure.
My lord.
Yes.
Yes, Lord. The submission made by the appellant that they have not given to others is not correct. Because
No, where is the order granting you a study leave?
granting me the study leave,
Yes.
that they have annexed notes. That is to their counter affidavit. I am enclosed here with the list of candidates admitted into post-basic BSc and MSc nursing course at Government College Nursing Berhampur, and against 85% government quota seats in private nursing colleges in the state during the academic session 2015 and 16. The above admission have been considered on the basis of NOC issued by the competent authority. That is given by the Director of Nursing.
What is the date?
This is the letter issued by the Director of Nursing. On the basis of that, I took admission in nursing.
Annexure I series.
Annexure B to the
No,
counter
whether
file.
this was study leave was granted.
No, study leave was granted thereafter. This
Where is the study leave?
the study leave, that is annexure 6 to my counter.
What is that?
Annexure 6, page 15
Yes.
of the writ application.
Yes.
But they have said MSc study leave period is granted in favor of Srimati Devika Mishra, the respondent, staff nurse, School of Nursing at MKCG Medical College, Berhampur, with effect from the date as mentioned against her name under Odisha Leave Rules 1966 as follows. So my name also they have indicated wrongly under the name as assistant surgeon. Although I am a staff nurse, they have indicated my name as Srimati Devika Mishra, assistant surgeon. And period of leave, they have given 17/11/2015 to 16/11/2017, treated as EOL. That I am challenging. That EOL, they shouldn't have written EOL.
So therefore, we are,
Yes.
what right did you have to get study leave? That is the question.
Yes.
What right do you have?
They in the counter, they say we did not grant to
Forget
study leave.
counter.
Yes.
Forget counter. Let us come to law.
On the basis of Exhibit 12, Annexure 12, Annexure 12 clarifies the position
See,
that
there was selection. There was selection
Yes.
for this training course,
yes,
not by your employer.
my employer, director himself,
Order.
director of nursing conducted the examination. I applied, I got selected. He directed me to grant study leave, but that was not granted on the basis that I have not
So
completed
who
5
was
years.
to
of-
grant you NOC?
My lords,
Who was required to grant you NOC?
the director,
The director conducted examination.
because
director was-
government refused that it could not, he recommended my name to the government again and again. He recommended my name to government again and again, but government sat over the matter, did not take a decision. And since there was delay in granting NOC and other things, I approached this honorable court, and this honorable court allowed me to participate in the examination. Thereafter, allowed me to take admission in the MSc course. It is their fault. They sat over the matter. They did not consider my case in spite of the recommendation of the director.
No,
Thereafter, I approached.
they are saying since you are not a regular employee.
I am
you are
a,
not-
why they say, because I have, as per the rules, after completion of 6 years of my service, I have to be regularized from the date on which I have completed 6 years. They sat over the matter, did not consider. Thereafter, I made several representations. They didn't consider. Again, I approached this honorable court saying that they are not considering in one hand, other hand, they are not allowing me to prosecute and not granting NOC. This honorable court intervened and directed to allow me to prosecute the MSc.
But by the time you had.
By the time when I
by the
prosecuted,
time you had not been regularized.
no, while I was prosecuting the MSc nursing course, they have regularized with retrospective effect.
No, there are two aspects, regularization and grant of study leave. These are two other different aspects.
Yes.
So you regularize, your services were regularized with effect from 15.
Yes.
But what right did you have to get study leave from that date? There are two
Because I was considered as a regular employee from that day on which date I.
All right.
Yes.
According to you, every person who is employed
Yes.
in the state government on regular basis has a right
Yes.
to get study leave.
Study leave, yes.
Where is that?
That is the rule 180.
Read it.
169, 180. Yes.
Read it. Then most of the employees will go for a study leave. All the employees of the state government shall go on a study leave and come thereafter and claim a study leave full salary.
No, provided they permit.
Yes.
They have allowed me to go.
So therefore we are asking, where is that? Allowing to go is a different thing.
Yes.
Allowing, if you seek permission, we also every day grant permission for people for the officers to go for a study leave. But do we grant them pay?
Yes.
Yes.
That
so
is
there
the rule
must be
itself.
leave method
I'm
now.
placing it. I'm placing it.
But
Oh.
your letter, it says as EOL.
My lords.
The letter permitting you to go on study leave, they specifically state that on EOL.
That is what I am challenging. That should not have been EOL because you have given that permission granting others to with all
Sir,
pay and allowances, everything.
You can challenge the grant of EOL on the ground that you had a right and therefore EOL ought not have been granted. So we are putting a very simple question. What right did you have to go on study leave? That's all.
Yes, I have got a right under the Orissa Service
All right.
Code.
We are on a different now question.
Now,
We are putting a different question.
yes,
This rule 180
Yes.
says ordinarily.
yes,
All right.
yes.
What is extraordinary about you?
Yes.
What is extraordinary about you?
External means I am fulfilling all the requirements. Similarly, placed persons have been allowed to go on study leave with all pay. And
See,
in my case, why?
when the rules say that ordinarily 5 years,
Yes.
then what is extraordinary about you?
No, I say I have completed 5 years. No question of extraordinary. I am ordinarily, I have completed the 5 years regular service. Therefore, I am entitled. In case of, even in case that I have not completed, then other things may arise.
But can it be regular service when you have been regularized from 2015?
Yes, that is a regular service because they have considered others also. Regular service, 2015,
So you went when?
2017.
So within 2 years you have gone, not 5 years.
There they are counting. There they are counting. I say that therefore a clarificatory notification was issued, that is exhibit annexure 12. I'm placing it, annexure 12. Page 7 of my rejoinder affidavit. That has been relied upon.
All right, we'll
Page-
apply our mind.
Page 7, annexure 12 to my rejoinder affidavit, that they themselves clarified that pursuing higher studies by in-service nursing personnel. You also got it? I'm reading it notes. In continuation to this department notification dated 2/1/2020, after careful consideration, the government have been pleased to allow the past service of the staff nurses. Those have already been regularized on completion of 6 years contractual service. The contractual service period will be treated as government service for the purpose of computation of 5 years of regular service under Rule 180 Orissa Service Code for grant of study leave in their favor.
Where is that? Where are you reading?
Page 53, annexure.
There is annexure 12, page 7 to my rejoinder. That is their own document, and on the basis of they have granted so many persons. I have prepared a affidavit today itself enclosing the relevant documents. That
Was it after this?
Yes, after this.
Notification or before this?
after
notification?
and before, both they have granted. Even after, before. Since they have argued it is prospective, not retrospective, I have two documents to show that those who have granted study leave along with me, they have been granted all study leave allowances and pay. That is the.
Yeah, then we should not. interfere.
Same.
My lord, the affidavit he served me today, had he served me
Since-
earlier, I would not have
since it
put
is
up.
argued that similarly persons, those who have granted study leave along with me, they have not given the benefit. I am enclosing those documents they have given, and they have not completed 5 years.
So, why, give her, give him.
I have given a copy.
Right now I got it.
It's not done. Do it, give him, we'll consider tomorrow. All right, we have a case because of that. And you have not filed.
No,
File it with the.
because they raised for the first time, they raised this point.
First time today?
And
You
last,
had the this red.
last occasion.
Why did you not file it
Today I
earlier?
got the opportunity to file it. Today I
Or
got the.
then if this is so, then.
If my lord, it has been given, because that goes contrary to my amendment,
Yes.
then I will not speak any further.
No, because it is not there on the board.
Yes.
Proper.
Next week. Then what they are.
As counsel appearing on behalf of the opposite party intends to file supplementary additional affidavit. Let it be done. So, this matter tomorrow. Tomorrow.
Let them.
Otherwise, we may forget the.
Yes.
Scanning.
Item number 5. Item 5.
May I please, Your Lordship? Lordship, in last occasion, I just,
You have a very bad case, madam.
I have something in my affidavit, Your Lordship, which I am filing today.
Affidavit,
I have filed today, Your Lordship.
what is there in the affidavit?
Your Lordship, I have collected some information, Your Lordship.
Then you seek a review.
Your
File a
Lordship,
review.
kindly see this affidavit.
Madam, we cannot see any document which was not there before the learned single judge. We cannot see any document. And we cannot rely on those documents for taking a different view than what has been taken by learned single judge. All right.
Your Lordship,
So
in
if
last
you
occasion,
have some new material, you can go before the learned single judge.
it's not the new material. In last occasion, Your Lordship asked me about the upgradation of qualification in the Hindi Teachers Training Certificate exam. So, as per my appeal, Your Lordship, to that effect, I am filing an affidavit. It is nothing new in that, Your Lordship. I placed this page for 54 before your lordship. Your lordship pointed out about the upgradation of the professional qualification. So to that effect, I'm filing this affidavit.
So how can we take note of certain fact which was not there before the learned single judge? How can we do that?
Your lordship, my only prayer that the petitioner is possessing the
Maybe
qualification.
possessing the qualification, but learned single judge based on the documents which were there before him, he has taken a decision. So how can we say that that judgment is incorrect because this is the document which he was not aware of?
Your lordship, here the petitioner is having the professional qualification.
Maybe having the professional qualification, but in the absence of the document which you are now relying on, whether your case can be accepted.
It was a query made by your lordship in
Query
last
because
occasion.
we make queries. If we committed mistake, then forget that, leave that query. We withdraw that query. And you withdraw your affidavit which you are filing. And then we will decide. All right. So our query withdrawn, your additional affidavit withdrawn, then
What I pray your lordship may kindly give a 1 minute chance, your lordship. May I place this page 55? Your lordship, here, at page 55, clause 11, your lordship. Page 55, your lordship.
page 55 of what?
Of my writ appeal.
Yes.
Your lordship, at point number 11, your lordship.
Page 55.
55, this clause number 11, your lordship.
Class upside down.
Yes. Yes, please read. We will try to read.
Hindi Teachers Training Certificate course conducted by the Hindi Training Institute, Cuttack, Bhubaneswar and Sambalpur is declared as equivalent to Sikya Sahayak Pranagat vis-a-vis BEd degree of an Indian university for the purpose of employment.
Yes.
So here the Hindi Teachers Training Certificate is treated as equal to that of Hindi Sikya Pranagat as vis-a-vis BEd, your lordship. And it is for only for the purpose of employment, your lordship. Here they have stated it clearly.
And every time you make us go through the entire document, so now you are referring to this,
Your lordship.
then we will have to see again the advertisement. So whether in the advertisement equivalent clause were there.
Your lordship, I have also placed it in last occasion. Today, if your lordship wants to place me the same, I will
Yes.
place it.
Because we have more briefs than you. So we have tendency to forget. Yes. Which advertisement?
At Annexure 3, your lordship.
Annexure?
3.
Annexure?
No, I'm coming to that advertisement, your lordship. Yes, it's Annexure 3. The equivalency is stated at page 44.
Yeah.
Annexure 3, page
Just a minute,
44.
just a minute. Annexure 3, page
44. It is starting from 45. The equivalency is at page 44, your lordship. At clause D, your lordship.
45.
44, your lordship. Page 44, clause D.
Clause D. Clause?
D.
Yes.
Such outside university or institution candidates shall have to produce the authenticated proof of equivalency and NCTE recognition in support of their qualification at the time of verification, failing which they will not be eligible in the selection.
Where are you reading?
Page 44, D.
D. D is classical Urdu, Fazal,
No, 44, internal 44.
internal 44 D, such outside universities. So where is your certificate?
Certificate is at page.
Starts at 35.
Page 39 is my certificate.
No, this certificate given by the DEO. This certificate given by the DEO, where is that?
I hear the clause says about the equivalency of qualification. And to that effect, my certificate is at page 39, you know.
Madam, your certificate can be treated to be equivalent, could be treated to be equivalent.
Your Lordship.
If it was, there was a certificate issued by the concerned DEO. If the DEO has certified,
Your Lordship, may kindly see my certificate.
please, you are relying on D.
The clause D which you pointed out,
Your
it says
Lordship.
that at that time you have to produce the equivalent certificate.
Yes.
So where is
Please
that?
read it.
So where is that?
Your Lordship, this certificate is dispatched by the,
Yes, dispatched by?
Your Lordship, I have pointed out. By the Director of Teachers Education, Your Lordship.
So
Sorry.
this is, what does it say? Regarding universities and institutions of outside, this is outside state. And you did your,
Inside.
from inside?
From Bhubaneswar College, J. Nagar College, Bhubaneswar, Your Lordship.
All right. So according to you, candidates having bachelor's degree in arts, commerce, science with bachelor degree in education from any university of the state or its equivalency. What does it mean? Equivalency. Are eligible.
Your Lordship.
All right, we are coming.
And beside this, one more point, if Your Lordship permit.
We are coming back.
I have annexed all the notification, Your Lordship.
So what was the training qualification required?
It's Natak and B.Ed and B.Ed, the professional qualification is B.Ed in Hindi.
Where is the training? What was the training required? Training qualification. About your VA, there is no dispute.
No,
So about your training, what was the training eligibility?
it's reflected at page 45 at clause F, Hindi teachers, bachelor's degree. The first part is concerned to the BA, and the second part, your lordship, if your lordship permit, I would like to place. Your lordship, the second part start from one Hindi. Page 45. It starts from page 45. The relevant portion is at page 46.
Yes.
Your lordship, and Hindi Sikyan Pranagat from Kendriya Hindi Sanstha Agra or BHED, a course prescribed by.
We are reading page 46.
Page 46. I am reading the relevant portion of the first paragraph.
Not telling us the background. As per what I have gathered from the order of the learned single judge, as per the 2014 advertisement, you were qualified, but you were above the age. So
Yes.
thereafter, that application was disposed of, saying that you will be granted the age benefit,
Your lordship.
42 years. So subsequently, when you applied, that
They rejected me for that I don't have the BA qualification.
because that another resolution had come by that time.
Your lordship.
So that is the problem.
Thereafter, they rejected me for the third time for professional qualification.
Then you came up and then you agreed when the court said that your representation will be disposed of. Right?
That why, yes, your lordship. That was before this, before rejecting me for my professional qualification.
So how do you say you have the professional qualification?
Because my
No,
professional.
do you say where on 2014 you had the equivalent qualification,
Your lordship.
but subsequently that cannot be
What
taken as
happened
equivalent.
since 1956 to 2013-14, this was in the advertisement. Subsequently, in the 14-15 advertisement, they deleted it.
Then you'll have to rely on that only.
Your lordship,
Your-
what my qualification is equivalent to this Hindi Sikya Pranagat. Therefore, I am before and the
Again,
notification
let us see the equivalence clause again. Where is that?
at 8, your lordship, annexure 5, page
Annexure
54.
5.
Your lordship.
5 series, which one?
Your lordship,
Oh.
page 54.
Where is the advertisement?
Advertisement is
Your qualification should be as per the advertisement.
your
Whether
lordship.
you have the qualification as per
Yes,
the
your lordship.
advertisement.
The advertisement is also saying about the equivalency. Your
Where is
lordship.
that?
At page 44, at clause D.
Yes.
Clause D says that such outside university or institution candidates shall have to produce the authenticated proof of equivalency and NCTE recognition in support of their qualification at the time of verification, failing which they will not be eligible in the selection process. Here they says the authenticated proof of equivalency, your lordship.
Madam, you are relying on D.
Your lordship.
So D is something different. D is your BA qualification. D does not deal with BA. Now, this argument you have met at least so many times. And on the last occasion also we had pointed that out. C, you are relying on D. D is regarding this A, B, and C.
Yes.
And then the training qualification comes at 4. 4. And therefore, for 4, there is no equivalence. Unnecessary, madam. All right, dismissed. Thank you. You did your best.
Your Lordship,
You did your best, madam.
last one more thing, if your
Sorry.
Lordship permit.
Sorry.
Just I have filed this citation of Honorable.
We will
Apex
consider
Court,
that.
2012.
We will consider.
It is already in the record, your Lordship.
We will consider.
2012.
We will give it. We will consider. So did you bring that decision to the notice of one single judge?
No.
Yes, next.
Item number 6.
Item number 6, my lord, on 15/7/24. My lord, as per my lord's direction, I have already served a copy of on my learned friend. There is a delay of 54 days, my lord.
Yes.
So if my lord may kindly condone the delay.
We are condoning it.
It's condone again. Will the condone? Probably it was condone.
Condone.
It was condone again.
All right, let us come to the merits. Yes.
My lord, the decision dated 6/11/23 of this honorable court of the honorable single judge is under challenge in this writ appeal, my lord.
Yes.
My lord, that is at page from page 13 to 25 of the writ appeal.
Yes.
Now, my lord, may I take, my lord?
Please. Yes.
May I take, my lord, straight away to page para 14 at page 24.
Yes.
I'm reading paragraph 14, ma'am.
Yes.
Be that as it may, by the time the Vigilance Department carried out the house search on 12/10/2010, the up-to-date property statement of the petitioner had already been filed on 15/9/2009. Moreover, the vigilance case registered against the petitioner in the year 2011 has not even progressed an inch. Even the charge sheet has not yet been filed. The promotions, meanwhile, have been given to the petitioner. It is right to say that the disciplinary proceeding must be conducted soon after the alleged irregularities are committed or soon after discovery of the irregularities. That cannot be initiated after lapse of considerable time. It would not be fair to the delinquent officer. Such delay also makes task of proving the charge difficult for the department. As such, it is also not in the interest of the administration. Delayed initiation of proceeding is bound to give room for allegation of bias, malafide and misuse of power. If the delay is too long and is unexplained, the court should interfere and quash the entire proceeding. But how long a delay is too long is the question stares on the face of the record of every case. In the instant case, delay of the initiation of department proceeding is about 10 years. That apart, the timing of initiation of the proceeding also smacks malafide intention. The department proceeding was initiated on 3/12/20. Whereas the petitioner's name was recommended for promotion to the highest cadre on 17/12/20. The department chose not to initiate the proceeding against the petitioner for 10 years. Rather granted 3 promotions meanwhile, and all of a sudden issued memo just 14 days before his name was considered for promotion to the highest cadre. Therefore, initiation of the departmental proceeding is not only hit by delay and laches, but also paused with malafide intention. Hence, this court considers it appropriate to quash the departmental proceeding initiated against the petition. My lord, we are aggrieved by this judgment. Now, there is a finding of malafide. My first humble submission before my lords is, then
Malafide, we can ignore that. But otherwise, what explanation do you have?
yes, ma'am. My second, this judgment was delivered by the Honorable Court on 6th November 23. Now, on 7/11/23, the charge sheet was filed.
So,
Well, I have a very limited, I understand the case, my lord, because I understand my limitations as well. Now, my only thing, why I will be aggrieved. My lord, my first submission to this honorable court would be probably, my lord, subject to my lord's acceptance, probably the legally acceptable course of action would have been if the honorable court would have directed to conclude the proceeding within 2 months. My lord, we have initiated a proceeding.
no. Delay in the initiation of proceeding may also be a ground for quashing the disciplinary proceeding itself. If the delay is inordinate,
Well,
like 10 years, everything was done. You could have taken a plea that you decided not to initiate disciplinary proceeding because there was a criminal proceeding pending. And you were waiting for the outcome of the result of the criminal case. The matter would have been different.
my lord, so such a stand has not been taken before
Alright,
this.
you did not take this stand.
But what you have stated before this honorable court, that it didn't
And
come to the
see,
notice of the
see,
appropriate authority.
See, after 10 years, you started a criminal proceeding. Criminal proceeding charge sheet has been submitted 12 years after
No.
this thing. We don't know what will happen in the criminal case. If in the criminal case he is convicted, you are at liberty to take any action which you can take under the law.
No.
That no observation of this court is required on that.
This is the limited question. This is the limited question because on 6/11 the judgment comes, on 7/11 the charge sheet was filed, and a departmental proceeding which was drawn up in 10 years. There is dilemma, no doubt. My lord, we will pray if my lord should have directed for conclusion of the proceeding within a very short period. That could have, my lord, would have reached its logical
That is
end.
not the question. Is initiation of departmental proceeding after 10 years when you had filed already criminal case. Either you could have initiated disciplinary proceeding, or as we said, that you could have waited for the criminal case. Could not have. And now, since the criminal case is pending, you can pursue that.
That malified part, my lord.
Is the criminal case pending?
Yes,
Criminal case.
charge sheet, 7/11/23. My lord, honestly, now also writ appeal doesn't solve any purpose because in any event we have the charge sheet has been filed in 7/11/23. It has its own consequential effect. So this pendency of a DP also would not have the same effect.
And whether he has been granted promotion.
No, ma'am.
Why, yes.
Yes,
He has been promoted.
I have succeeded in that scat. He has filed a case in the Central Administrative Tribunal.
Now, has he been given promotion to?
He is retired in the meantime. That part I will.
He has not
He
been
retired in the meantime.
He has not been granted promotion.
No, by protocol.
Huh?
I have not instructs on that, but he has
No,
retired
I
in the
say
meantime.
he has not been granted.
He won the case in the Central Administrative Tribunal. That is.
That's all.
Right.
What about malified? See.
No, my lord. That is up to my lord.
That is
Because neither there was any, my lord,
no
any
pleading.
conclusion.
No
Yes.
malified against none.
Yes, and no party, if malified is to be attributed, then
Person.
there is no no such party before this honorable.
The state of Odisha has put to challenge in the present intra-court appeal a judgment dated 6/11/2023 passed by a learned single judge of this court in WPC number 33496 of 2021, bracketed Surat Chandra Malik versus State of Odisha and others, and another. Full stop. By the impugned order, next one, by the impugned order, please take your seat. By the impugned order, learned single judge has set aside an office memorandum number 26999/Jan dated 3/12/2022.
2020.
20, whereby charge sheet was framed. This was charge sheet.
Yes, this is the charge in the proceeding, department proceeding.
Whereby departmental proceeding was initiated against the respondent with the framing of charges. First off. Next. Briefly narrated, the relevant facts of relevant facts for adjudication of the present appeal are that the respondent number 1 was a member of Odisha Administrative Service.
Administrative service.
OS.
Ah,
OS.
Odisha, yes, yes.
Was a promotion to IS.
Vigilance case was filed against him on 12/10/2010, while Cuttack Vigilance PS case number 55 of 2011, corresponding to VGR case number 55 of 2011, for acquiring property disproportionate to his all known sources of income. This was the allegation. Huh? So, learned single judge has paused the departmental proceeding mainly on the ground that though the criminal case was filed against the respondent in 2010, on the same set of facts, departmental proceeding was sought to be initiated in 2020, much period, more than a decade thereafter, without any plausible explanation. Full stop. The facts that the respondent's name was under consideration for promotion to Indian Administrative Service have also been taken note of by the learned single judge. Oh, stop. Learned single judge no, but he was granted promotion
In the meantime,
in the
between
meantime.
2010 to 20, he was granted three other promotions. In the OS cadre,
No, he was granted notional promotion to IAS also.
yes, IAS, my lord, what happened? I was the conducting counsel, my lord. UPSC has given me the promotion because they have instituted this particular proceeding. It was kept in sealed cover. Thereafter, I filed a case in the CAT after disposal, and CAT has allowed my case. But effective promotion has not given to me. In the meantime, I have retired. There is a contempt proceeding pending in the CAT. That is the fact. But I have been cleared by the UPSC.
Only when promotion order is granted, then only promotion takes effect now.
That is
Only when
correct.
promotion, because selection committee kept the matter in seal cover. So promotion not granted.
No, CAT has allowed it.
That has allowed it, but my lord is asking me whether promotion was granted or not. Promotion was not never granted. Promotion is granted when the promotion order is given effect.
All right.
Madam.
So notification has not been issued by the central government.
No.
So that is to be under the seal of the President of India. That has not been
Yes,
issued. Then.
yes.
क्या लिखा? Got it. Learned single judge has also taken note of the fact that the respondent had submitted the details of his property statement before registration of the FIR on 15/9/2009. Full stop. Next, Mr. Misal and AGA appearing on behalf of the appellant has made twofold submissions. Stop. He firstly submits that a departmental proceeding should not be quashed on the ground of delay. Stop. Instead of quashing the charge sheet / departmental proceeding, learned single judge could have directed the disciplinary authority to conclude the departmental proceeding expeditiously. Stop. He has further submitted that learned single judge has held the act of initiation of departmental proceeding 10 years after lodging of the FIR as an act of malafide without there being any such allegation made in the writ petition. Stop. Next, Mr. Das, learned counsel representing on behalf of the respondent has submitted that when single judge has rightly taken note of the Supreme Court's decisions in case of State of Madhya Pradesh versus Bani Singh and another bracketed AIR 1990 SC 130 and M. Bijlani versus Union of India reported in 2006, volume 5 SCC 88, before reaching a conclusion that unexplained delay and latches on the part of the department to initiate. That is conclusion. This is not initiation, Mr. Long pending.
Yes.
A long pending. There is difference between the two.
Yes, sir.
These two judgments don't apply.
No. Bani Singh, my lord, can't have this.
Bani Singh is?
Madhya Pradesh.
Bani Singh is conclusion or initiation?
Delay in initiation.
See it. And Bijlani is,
Vigilant followed this vanishing. Vanishing is the first one, my lord, in this kind.
issuing such charge. Yes. इसको दूसरा वाले पढ़ रहा है ना, वो बानिस। क्या लिखे? क्या लिखे? क्या बोल?
Paragraph
Before
4 में
reaching-
kindly see.
Before reaching a conclusion that in the absence of any satisfactory explanation for inordinate delay in the issuance of the charge memo, comma, the disciplinary proceeding deserved to be quashed. First off, he has submitted that there is no illegality in that he has submitted that the said opinion formed by the learned single judge is legally sound and does not require any interference. So he has, however, submitted that he shall have no objection if the finding of mala fide recorded in the impugned judgment is expunged. That can be done, Mr.
Well, on court is also only observation. That is not a finding.
No, there is absolutely.
Only the court has said in this way, my lord. As
Yes,
such-
yes, that we have seen. That-
As
that-
such, it is also
See,
not in the interest of
mala
administration.
fide, when you say mala fide,
Yes, that,
mala
that
fide has, mala fide has two elements.
yes,
One, malice in fact. Two, malice in law. Both is
Yes.
mala fide. So this can be malice in law and therefore mala fide.
otherwise,
Nothing wrong.
personal,
Yes.
yes,
So
that is right.
if it is a malice in fact, then of course that is against a person. If
Then-
something is malice in law, then malice in law, mala fide, that
Correct.
may also be mala
That
fide.
is noticed.
Still we can
Yes,
ignore on
yes,
this.
no problem.
Next, after having considered rival submissions made on behalf of the Mr. Mishal and AGA and Mr. Das and counsel for the respondent, we are of the view that the impugned decision, to the extent it has caused the disciplinary proceeding, does not suffer from any legal infirmity requiring this court's interference in intra-court appeal. First off, in case of vanishing bracketed supra, the departmental proceeding was initiated 12 years
Yes.
after the department was aware of the involvement of the officer in the irregularities for which he was, for which a departmental proceeding, for which the same was initiated. First off,
But here they were aware from the day one.
in the absence of any justifiable explanation, the Supreme Court, in case of vanishing, has paused the departmental proceeding on the ground of delay and latch. No, the CAT had paused.
Yes. Tribunal has was
and
upheld by this.
upheld the decision of the Central Administrative Tribunal to quash the disciplinary proceeding. Stop. Next. This. However, the finding. However, any observation made in the impugned order to the extent the same relates to mala fide stands expunged in the absence of any specific pleading in the writ petition in that regard. So it goes without saying that the state shall be at liberty to proceed depending upon the outcome of the criminal case.
Bless.
Disposes of the written. Yes.
Item number 7.
But I have challenged the order of the Honorable Single Judge in Annexure 11, page 42. Denying my lord the benefit of salary on the basis of the decision in Tarsensi.
Incarceration.
Well, that was the observation. If you also look at the judgment dated 15/12/2023.
So according to you, you were in custody.
So Tarsensi, my lord, that salary is to be paid, my lord, 3 years prior to grant of granting aid. That was the case. And in Tarsen Singh's case, my lord, 16 years after, my lord, the person concerned approached the authority for grant of pension.
So what do you want?
My lord, but so far the Tarsen Singh application of Tarsen Singh in respect of this kind of cases, my lord, though initially there was no decision, subsequently decision has come and it has been upheld by the Supreme Court, implemented by the government. And in respect of my college also, my lord, 3 of my colleagues and the other.
No, that is immaterial. We are testing the legality of the order. How do you say that this order is not legal?
Because, my lord, if you watch the first order, the first order was passed by this honorable court, my lord, pursuant to his granting was given to me. In that order, my lord, kindly come to page, that is Annexure 2.
Annexure 2?
Yes, sir. Page 21.
In your case?
Yes, sir.
Yes.
Relevant portion, my lord, page 21.
Yes.
In this third line, in the event appointment of the petitioner is approved, because by that time my appointment was approved, all the financial benefits shall be given to her following such approval. The entire exercise shall be completed as early as possible, preferably within a period of 3 months from the date of production of certified copy of the order. The area dues, if any, shall be paid in consonance with the judgment rendered in appeals court in case of so and so, 2008, 8 Supreme Court, Ballot 648. Based on that merit, my order of approval, Annexure 3 was issued.
Then?
Because thereafter, my lord, when other cases has come, I approached my lord, this honorable court saying that the issue has now been settled.
By state?
By this honorable court, my lord.
Where is that settled?
That is, my lord, Navagan Das case, my lord. If you also look at the second order passed by
Mr. Tripathi, that Annexure 2, there this court has specifically stated that if you are entitled, it will be given
I'm not disputing
in consonance with Tarsen Singh.
Yes, madam.
Yes.
But by that time, my lord, that issue was never adjudicated. On the first day, my lord, the order was passed. Since the order was passed,
So that order was illegal?
No, I'm not saying my lord, illegal, but subsequently that issue was taken up by this honorable court and considered
But have you
on
challenged,
merits.
have you challenged that order?
No, I have approached this honorable court again, madam.
No, regarding that Tarsen Singh.
Tarsen Singh, my lord, I have approached this honorable court saying that in the meantime, Tarsen Singh has been changed in respect of granting aid cases. And this honorable court directed you reconsider.
Where is that reconsider?
My lord. My lord, the second order was passed on Annexure 4, my lord, page 24. Because in my representation, I have highlighted, my lord, those cases.
Sir, this is something else. There is nothing in 24.
But page 26, my lord, the relevant portion is 26.
Yes, reconsider representation.
Yes, sir. Then, my lord,
In your opinion.
So why do you rely on this?
Because my lord, subsequently I have filed application. I am not challenged, my lord, writ appeal against
You
the
are
past
relying
order.
on what? Which order of the Supreme Court, which order of the High Court, or which order of the government?
My lord, initially, my lord, I have not approached this honorable court in writ appeal against the first order. That's a mistake, my lord.
So
But
that is the wrong order. Just a minute.
My lord,
What is the date?
that date of order is, my lord, 19/8/2015.
19/8/2015.
In documentation number.
Just a minute.
My lord,
Is a wrong order which you missed to challenge.
I have not said wrong order because I have not challenged that.
Therefore, you ought to have challenged, but
But I have not challenged.
yes,
Yes.
missed to challenge.
Then, my lord, government, when government granted, my lord, my benefit, restricting, my lord, 3 years prior to the date of release, my lord, I approached this honorable court again, my lord. Again, my lord, that is order is annexure. That order, my lord, reconsideration order was passed, that is on 23/12/2019. 23/12/2019.
23/12/2019.
Yes, ma'am.
This is representation.
Yes, ma'am.
This is not an order.
No, representation.
This is nothing.
No, no.
Not
Yes,
an
ma'am.
order.
But the direction for reconsideration.
Where is the question of reconsideration?
Take a decision on my representation.
Take a decision is
Yes,
not
yes.
reconsideration.
Madam.
Because
Reconsideration can happen only after setting aside something.
So, Mr. Tripathi, with that order of the High Court, could the authority have taken a different decision?
I don't follow.
With that earlier order of this High Court,
Madam.
could the authority taken a different decision?
No, could not have.
So,
I'm not saying that, madam. When subsequent development has taken place, madam, if you also look at
Where is that subsequent development?
my subsequent development, if you also the third order that came on 19/8/2021, when they have rejected, madam, then I approached this honorable court again, madam, on page 31.
Yes.
They have said, madam, following Navagananda's case, madam, page 32, madam, all the financial benefits shall be given to her following such approval. The entire exercise within a period of 3 months.
So what is Nagavananda?
But thereafter, my lord, they have said the rejection came in Annexure 7, my lord, 26/11/2021. They have said in your case, when the order was passed, we cannot take a different view. We cannot take it. The government has said that since your order was passed in your case in that line, so your application is rejected.
So what is Nagavananda?
Navaganda's case, my lord, that is that Tarsen Singh judgment has no application to that.
Where
And
is that judgment?
My lord, that judgment, my lord, if you also look at the second, another judgment, my lord, I have also taken in the writ appeal, my lord.
So this judgment was considered by the learned single judge.
Not considered, my lord. I have shown to every order, but my lord has said since in your case order was passed, we cannot see the
Just a minute. Whether this judgment was considered by the learned single judge.
No, I have filed, my lord, all the judgments.
no, what is the order of the
Order, my lord, my lord's order is annexed to page 42, my lord. The honorable single judge order, my lord, page 42.
42 or 31?
So where have you taken this point that you relied on and it was not considered?
My lord, it is there, my lord. In the petition, if you also look at the petition. In the petition, my lord, kindly come to page annexure 4.
Not in annexure 4. Where have you taken this point in your writ appeal that you relied on this decision,
My lord.
but single judge has not considered?
My lord, kindly come to para 11. My lord.
Read it.
Yes, ma'am. After this rejection order, my lord, but unfortunately, government, without considering the case of the applicant in accordance with the law, and the decision rendered either in Navagananda or in the case of Banlata Mahapatra, has rejected her claim for release of differential salary from 94 to 2011, was further illegally rejected by the opposite party number 1, reiterating earlier decision communicated so and so. It is worth indicating that the applicant has got full information in case of another case, my lord. And I have taken the plea, my lord, in the grounds, my lord. I have shown Banlata Mahapatra and Narendra's judgment.
Mr. have you taken a plea that this decision was shown to the learned single judge, but the learned single judge declined to notice this decision?
My lord, not in that line, that,
Not in that line, then that is not a ground
my lord,
for appeal.
I've said, my lord, I've taken that, I've shown that
No,
judgment also.
No,
I've taken that,
unless you demonstrate
my lord.
that all these points were taken before the learned single judge, but the learned single judge did not notice, you cannot assail that order. You can seek review that, see, this is the order which could not be brought to your notice, or brought to the court's notice, that this order is binding, which could not be brought to the notice.
But I have taken, my lord, para B, my lord, I've taken that the honorable single judge has not concerned, thereby ignored the expense ground in the writ petition. I've taken regarding Banlata Mahapatra and Navagananda.
Not Navaganananda, you have said Narayan Das.
Banlata Mahapatra, Narayan Das, and the para 9 number is also the Navagan Das. Navagan Das case, my lord, is also indicated in the order itself, my lord, in those 3 orders.
All right. Yes. Yes.
My lord, this honorable court specifically directed for consideration in view of Tarsan Singh. We could not have gone out of that. That was the direction of this honorable court. And we have only obeyed that order. And the contention of my lord senior that this applicability of Tarsan Singh has been diluted. My lord, my humble submission, it's not correct. That's all.
My lord, based on Banlata Mahapatra's judgment, my lord, I can show to your lordships, my lord. In 7 of my cases, my lord, a batch.
See, you are asking them to commit contempt of court.
Well, if your lordship will take an annexure 1.
There is a direction of this court that your case is to be considered in case of Tarsan Singh.
I'm not denying that position. I'm not denying.
Then you are not denying.
Subsequently, my lord, this honorable court considered the case and in subsequent writ application saying that you consider. Then, my lord, and concerning accordance with law.
Therefore, your case was decided in terms of Tarsan Singh.
But there was, my lord, a large number of cases your lordship disposed of.
Maybe.
The first day disposal, my lord. If I'm not.
We will see. First day disposal.
On the same date, the first order was passed, my lord, without counting everything.
All right, we will see.
That first order passed on the first day. But you have not challenged. That is the problem.
I'm not disputing. I'm not challenging. But subsequently, my lord, when it has come to my notice that this case has been considered by.
Mr. The moment some other decision came, you could have filed a review. You could have done anything. But how can in your case that judgment is applicable, that order is applicable?
Well, I'm not denying that, my lord. But subsequently, my lord, when my case,
all right, we will pass order tomorrow.
3 petitions, my lord, and 3.
Tomorrow. Oh, sorry. Tomorrow.
And now, my lord, that Navagan Das and Banlata Mahapatra has having been accepted by the Supreme Court, my lord. Large number, even my lord, last month.
We are not saying that, but that order stays in your face. That is the problem. They could not have done anything.
But they could have reconsidered when the subsequent order started. I leave it to yours.
Item number 8.
And all in my case, in my college, my lord, all have got. Even my colleagues have got.
Therefore, who will set aside that order?
By operation of law, my lord, your lordship can set it. By operation of law, my lord. Some entitlement. It's a case of entitlement.
You accept the order, you take the order, you accept the order. Now later you realize that that order was wrong. Very difficult.
No, but based on the subsequent judgment.
Item 8.
I keep your lordship to consider that.
Tomorrow we will dictate the order in the courtroom.
No, my prayer may not to consider all the.
Yes. To the extent it is, that depends on our capacity also.
Item 8, I received the appeal memo yesterday evening, my lord. I pray for next week.
As requested on behalf of the respondent. on the ground that he has received the memo of appeal only yesterday, I'll list this matter on next week.
My lord, my lord senior has already stated that, but my lord will remember this case relates to work charge. My lords have fixed identical matters. My lord will remember back, my lord, when former AG was addressing my lord on the issue to 22-8. All these matters are fixed to 22-8.
22-8? And some matter was being mentioned where there is Supreme Court direction to dispose of.
That is the job contract matter. That is the job contract matter. Supreme Court has stayed it. This is work charge.
No.
State or to some case they have asked to dispose of expeditiously.
That matter has not come. Lordship has fixed that.
But what is that subject matter?
That is a Hindi teacher recruitment matter.
That was fixed for today.
That was fixed. Perhaps that was fixed for today, but it has not come.
Just give one case number, he will check.
I'm just.
सुप्रीम कोर्ट का जितना भी मैटर है फाइंड आउट फिर तो वो दिए देंगे तो मुश्किल हो जाएगा why that has not been listed so I'll check that
Oh, was it in the list and did not reach? That is it. Check,
no,
check.
it was not in the list.
Okay. Check and otherwise tomorrow.
Next.
Item 9.
I'm appearing for the respondent, Your Lordship. I'm appearing for the respondent. On behalf of Mr. Raut, I kindly pray this matter be taken up next week, Your Lordship. Some difficulty.
You are for the appellant.
So I am another respondent.
Who is for the appellant?
Yes,
Appellant on behalf of SN Patnaik.
So everyone is trying to flee away because of you.
Any day next week.
You're for the appellant. You also
Yes.
want time.
No,
You're ready.
They're taking time, respondent are taking time. So on behalf of SN Patnaik, I am.
As jointly requested on behalf of the parties, this matter on when?
Any day next week, Your Lordship. Any day next week.
Item number 10.
My defer that WA number 557 of 2022.
Which item?
No,
That matter you also asked me that matter super.
557 2023.
My lord, this item number 10, my lord. My lord, I have the instruction to appear on behalf of the respondents 1 to 11, my lord. I was also representing them in the writ petition, my lord. They were the petitioners. Lord Bhakladnama, I pray, my lord, 2 weeks time. I will also get prepared, my lord.
It is stated by
Trilochan Nanda.
Mr. Trilochan Nanda Land Council that he has instructions to appear on behalf of respondents number 1 to 11.
1 to 11.
And he shall be filing wakalatnama in this regard by today.
My
By
lord,
today,
my lord, next, within this week, my lord.
by next Monday. So stop. List this matter on 2 weeks. Yes.
My lord, interim order mentioned, interim order passed earlier.
Interim order is there.
Yes.
That continue. Interim order.
Item number 11.
Obliged, my lord.
You are Mr. Sahu?
My lord.
All right.
Item 11.
Item 11, my long friend has appeared. This is regarding the rehabilitation matter. We have already disposed of this. And this matter delay has been condoned. Already delay condoned on 3/7/2024.
All right.
Have given.
Item number 12.
Challenging, Lord.
Annexure 10 below. And in the read petition, challenge the order dated 17/5/2014, 24. That's the annexure 9. And the annexure 10 is the impugned order. And annexure 10 page note 115 and 116 is the findings. And the page 115 para 7.
This appeal is maintainable.
Yes, ma'am, that's the final order.
Election tribunal order.
No, that's not the election
Tribunal
tribunal
order. Interim order passed by the election tribunal. You file writ petition. The writ petition was filed under Article 227. So the writ petition, writ appeal will not lie.
See, this is Lord, the petitioner has not been provided to chance to adduce the evidence, ma'am.
Maybe just see the order.
Yes, ma'am.
Petitioner has challenged so and so, wherein prayer of the petitioner under order 41 rule 27 has been rejected.
Yes, ma'am.
So this is a judicial order.
Yes, ma'am.
So against that you filed a petition before this court.
That's under election case, Lord. That's the under the statute of the Gram Panchayat, Lord. The election dispute, the Sarpanch election has been challenged, and during the trial, the petitioner is the elected candidate with the OP number 1 and the written candidate was not provided a chance to adduce the evidence. And my lordship, well, the first, my lord, the annexure 3
If you
below.
start entertaining such appeals, then election petitions shall never be decided.
I don't know.
If we start entertaining such appeals, then election petitions shall never be decided.
No,
Let
no,
them
my
be
lordship,
decided.
I have filed evidence in chief. That's on record. And the findings is, my lordship, findings is deliberately did not adduce her evidence. My lordship,
Sorry.
and within 10, my lord, within 18 days, working days, 8 dates have been passed. I will show, my lord, only 8 dates, my lord. Yes, ma'am.
Go there, not here. Let that be concluded first. An order dated 5/7/2024, passed in WPC number 15319 of 2024 by a learned single judge of this court is under challenge in the present intra-court appeal. Full stop. The petitioner before the learned single judge had challenged an order dated 17/5/2024 passed by the learned additional district judge, Kantamal in election appeal number 1 of 2023, whereby petitioners, whereby the prayer of the respondent under order 41 rule 27 was rejected. Full stop. And single judge has noted in the impugned order that the petitioner had deliberately not taken steps before the learned single judge and did her best to delay the trial. Full stop. She approached this court against different orders of the trial court on different occasions. Full stop. By operation of the order of this court, though she was allowed to take part in the proceeding before the trial court and was granted sufficient opportunity to adduce her evidence, she deliberately lost multiple opportunities in that respect. Full stop. Next. Learned counsel appearing on behalf of the petitioner has, appellant has attempted to submit that the appellate court, that the court of learned additional district judge, Contempt, has granted 8 adjournments
No, my lord. The Lord Election Tribunal is recorded 8 dates where different petitions have been
And
moved
the
and has been,
election tribunal has,
and I have filed before the Lord Election Tribunal
we are
the
going to
evidence in
impose
chief.
cost, Mr. Counsel, so that next time you will not come.
No, my lord.
These are the facts which have been noted by learned single judge. Now, what is your submission?
My lord, see, that is the under the Gram Panchayat, at the Gram Panchayat election.
Learned counsel has submitted that the
My lord, see,
a learned court where the election case is pending. What is the number of
election case is not pending, my lord. Election case has been closed. Then the election writ appeal is, my lord, the appeal is pending. At the time of appeal, I prayed for additional evidence, my lord.
Lord counsel for the appellant has submitted that the appellate court has wrongly rejected the appellant's prayer for adducing additional evidence. Stop. Next. After having seen the impugned order, peruse the impugned order passed by the learned single judge and conduct of the appellant in approaching this court by filing present intra-court appeal against an order passed by the
appeal is
learned single
posted
judge,
26 July for judgment.
apparently under Article 227 of the Constitution of India, this appeal deserves to be dismissed as not maintainable with a cost of rupees 10,000 to be deposited in the account of advocate welfare.
My lord, cost may be exonerated, my lord. The interior village people, my lord.
Yes.
Interior village people, cost may be ignored, my lord.
Not in this case.
My lord, I am appearing for opposite party number 1.
Yes.
You want to accept notice? Then, have you appeared? Have you filed a wakalatnama?
Yes, my lord. But in counter. Counter I have filed, today filed.
You file your wakalatnama?
Yes,
What is your name?
Advocate Tushar Kumar Mishra and associates.
All right, next.
Item 13 on behalf of Mr. Mishra, my lord. It is similar matter has posted for judgment, my lord. Hearing has already been concluded. The virus matter, my lord. The challenging the granting order 2004. The similar cases has already been, hearing has already been concluded and posted for judgment, my lord. Kindly taken up after pronouncement of judgment, my lord.
Which case?
Item 13, my lord. In item 13,
Heard by which bench?
this bench, my lord. 2004 granted order has been repealed. That has been challenged in this. In separate batch of cases has been hard one.
What is the case number there? What is the case number? In which the judgment has been reserved.
I have on behalf of Mr. Mishra, my lord, I have given one.
Give the
Order, no. Yes, my lord. Order is reserved in that batch of cases. Because my lord sitting with Justice Raman, my lord.
Exactly, because I don't remember. I was thinking I'm having some amnesia or something.
Sorry, sir.
That is why I asked.
I'm sorry, sir.
The 2004 repeal act, the Anup Senapati case that we are arguing.
Oh,
that matter.
yes. Yes, list this matter after disposal of. List this matter on 4 weeks. 4 weeks. Tomorrow.
Yep.
May I please, Your Lord? My lord, in this case, my lord, present petitioner pray for extension of the lease period, my lord.
Extension of?
Extension of lease period, my lord. Your lordship kindly peruse
the annexure 1, my lord. The lease deed number, annexure 1 series, page 16, my lord, where the lease deed number 141902.
Annexure 1.
Yes, my lord. Annexure 1 series, my lord. That executed on dated 28/8/2019, my lord.
So what
And-
for? What is your prayer?
Prayer, my lord. Now the agreement period exists till now, but EC not issued, my lord, in favor of present petitioner, my lord. So that's why the present petitioner not running the query. Your lordship kindly peruse the now our agreement period exists till 27/8/2024, my lord. Thereafter, my lord, your lordship kindly peruse Annexure 4 series, running page 57, my lord. Your lordship got it, my lord.
Yes.
The operation order for the remaining period of arrest, Khanjama Madhusudan Stone Quarry, number 59. The portion the approved mining plan as regarded Khanjama Stone Quarry 59 submitted the mining officers Baripada Circle, Baripada, as per the agreement, lease deed number.
Mister, what do you want?
My lord, the opposite party not issue.
Which opposite party?
Opposite party number 6, my lord.
Who is he?
He is, my lord. He is the chairman, State Environment Impact Assembly Authority, SIA, and also the Tahsildar. Two.
You can file a representation.
My lord. My lord, in last occasion, your lordship directed to file affidavit, my lord. The document. My lord, my repentance is also pending in Annexure 10. Annexure 10, my lord.
Who is the authority? Which authority is not considering?
My lord, SIA, Chairman, State Environment Impact Assessment of the SIA.
Pending,
Opposite party number 6, my lord.
pending since when?
Since long, my lord.
Long means 10
Long
years,
means
2 years, 3 years.
Yes, 2 years. Thereafter, recent also a file on dated 24.
So what are you doing since 2 years?
My lord, nothing, my lord, because only issue the EC in Annexure 4, my lord, 2019, my
What
lord.
for have you given this? What is this?
That is the additional affidavit.
If that additional affidavit, that we could understand.
Yes, my lord.
But what is there in the additional affidavit?
An additional affidavit, because what happened, my lord, enter Green Tribunal, pass this order for the entire quarry, my lord. Total in this area, 69 quarries involved. After disposal of the Green Tribunal, my lord, all the agreement executed. So that's why thereafter the authority stated that we must make out a cluster for all quarry, distance between 500 kilometers to one quarry to another quarry. Thereafter, they have not issued, opposite party 5 and 3 also not issued the fresh EC against the present petitioner. Well,
Have you checked up? If I remember correctly, I don't know if it is this cluster or not. The NGT had issued a stay order.
no, NGT order already.
It is not, no, had initially issued a stay order. Thereafter, it was vacated. So
Yes,
this
ma'am.
court in a number of decisions has extended the period. Are you aware?
Yes, ma'am.
So where are those orders?
Yes, that is all.
You give them an order, let them check up whether it's the same
Already
thing or not.
they council know this.
Already given.
And even otherwise, this is going to lapse on 27/8.
Yes, ma'am.
This matter is over almost.
Competence.
So even if we pass some order, nothing can be done.
No, what happened, my lord? We are the present petition not operated the quarry in 2 years, my lord.
So,
Due to the lacuna of the opposite parties, my lord, because they have not issued the EC, my lord, because present petition file all royalties, all environment.
Then it is slightly different. In those cases, everything
Yes.
was there, but because of the stay order.
Yes, stay order by the Green
So
Tribunal.
your case is different. That is why you
Because,
have.
he
Yes,
doesn't have that
Yes, ma'am.
clearance.
See, EC is to be
Now,
issued.
our case is, my lord.
All right, after.
After lunch, we'll take.
Okay.
My belongings, that's what I'm clear.
So remove.
No.
You want 1 month time? To
Yes,
remove.
it's only this.
See, who is going to remove?
So tomorrow they will demolish.
Who?
Milord.
Who will remove? Mr. Kutia or?
Tahsildar. Milord.
So, Mr.
Therefore,
Kutia.
Mr. Kutia. All right, he may seek instructions. We will take up your matter at 4.
Yes, Milord.
Item 14.
May I please, your lords? My lord, what happened, my lord? In this case, the lease period is continuing till 27 for 2007, 28, 2024, my lord. But only the authority issue the EC for environment clearance for the 2021 only. For the only one, the annexer is, my lord.
So you are seeking direction for extending the lease period or for grant of EC?
Grant of EC, and even if the lease period is continuing, my lord, not EC not issued, for which the present petitioner not operating the quarry properly, my lord. In the 2 years already lapsed, my lord, because he has deposited all royalty amount and enter pollution amount, my lord. They are only.
So you are not properly doing what?
No. What happened, my lord? In the meantime,
Doing something but improperly. You are extracting mineral.
Stone quarry, my lord. Stone quarry.
Stone quarry. Not properly.
And yes, properly, my lord. But environment clearance not issued against us, my lord. After.
So despite environment clearance not having been issued, you are doing it.
No, my lord. We are operating till now, but only 1 year already operated.
Without the EC, you have operated for 1 year.
No, is issued in favor of us in Annexure 4. Annexure 4 is your lordship, kindly spare.
So what do you want us to do?
In present petitioner want to
pass an order. Like if we are required to pass an order,
extension of
if
our
we
lease period.
ask you to pass an order, then what order will you pass?
Extension of lease period, my lord.
Because you don't have AC, there is no question of extension of lease period.
My lord, EC is not issued by the authority, my lord.
Which authority?
Authority of opposite part number 3 and 5, my lord.
So they are two different things, two different persons. One has to issue, extend your period of lease, other has to grant you EC.
Yes, my lord. Our prayer is, my lord, issue the EC, my lord, environment clearance against the present petitioner, for which the quarry will be operated.
Petitioner or in favor of?
Our representation also pending in Annexure 10 before the authority, my lord.
Which authority?
Opposite part number 5.
Which is opposite part?
Opposite part number 5 and also 3.
Yes.
Yeah, opposite party for who, my lord? Opposite party 5 mining officer Baleswar.
He will grant EC?
Yes, my lord.
EC he will grant?
Mining officer. And EC will grant the chairman State Environment Impact Assessment Authority, opposite part number 6, my lord.
Opposite part number 6. Who represents opposite part number 6?
Opposite part chairman State Environment Impact.
Yes, they've got a different concept because it's pollution control under the pollution control board. They are different authority altogether.
Issue notice, pollution control board. Have you pleaded?
The Chairman State Environment Impact.
My lord. Yes.
See,
opposite part number 6.
Please let us know who will grant you the environment clearance.
My lord, opposite part number 6, man.
Who is opposite party number 6?
Chairman State Environment Impact Assessment Authority. SIA.
Yes, so the state government officer.
No, it's independent authority altogether now.
All right. Issue notice, respond number 6. 1 week, 6 weeks. Yes.
Item 15.
Your Lordship picks up the date, my lord.
Yes.
I may pardon, my lord. I may pardon to make mention, but item 12, my lord, I prefer withdrawal, my lord.
Paper?
Prefer withdrawal of the case. I will be misunderstood by the client, my lord. Item 12, my lord.
12 withdraw. Order.
Public.
Item 15.
May I please, Lordship? Lordship, in this matter, I have challenged the extension notification, Lordship. I have challenged the extension notification, Lordship, person to
Extension of?
extension notification, Lordship, under CGST Act.
So when are those matters?
Similar matters, I have already given the order. After this. Same party, Lordship, only year is different. No, after this, there is one order for. On 10th of this month, matter was there, but no date has been given.
No date?
No date has been, the order is not uploaded, Lordship.
That order has not been uploaded.
Yes, Lordship.
8 weeks time is granted.
No, that is different. That is GST environment.
So in this case, Mr. Bimarana
For
accept
settled
notice.
GST.
Who accepts notice on behalf of central government?
I vote 3 and 4. I am for 4 and 5. State GST. State GST, Union of India and.
I am for opinion 1 and 2.
Please give your slips.
Obliged.
Item number 16.
That's item number 16. The second writ petition is here, my lords. But the second writ petition, the only thing, my lords, it is tagged to 15588/2023. That is the primary matter where the first order was issued. And all of us are selling in the same boat. The second matter, my lords, on today's board. Now, the second matter's fate will decide the first matter subject, my lords. It is relevant. That order is very relevant, my lords. So these are the writ petitions, my lords, that have to be tagged along with this. Same orders have been passed as has been passed in the second writ petition, my lords. And all of them deal with the imposition of additional charge by the government with regard to the leaseholders. So that if that is adjudicated in my favor, then the second writ I will get, and anyway I'll get the Y forms. If it is not adjudicated in my favor, these matters are not adjudicated in my favor, then that I don't have any case. So all these matters can be tagged up. One counter has been filed. In my case, no counter has been filed.
So when are those matters coming?
31/7/2024.
According to learned counsel for the petitioner, the legal issue involved in these two matters are identical to those involved in WPC number so and batch. Stop. Place this matter on 31/7/2024 along with WPC number so and batch.
Much obliged, lords. Much obliged.
Item 17.
Lords, my counter has not been filed. Just an instruction to file. Yes.
Lord, I rely on the judgment passed by your lordships is regarding the nursing colleges, the admission rules. So what has happened is the state government, in violation of the rules framed by the INC, have not reduced the percentile for admission for SC/ST students, which is under the INC. So I'll just take your lordships to the INC regulation, which starts from page 33. If you
Page
33, it starts. Your lordships may come to page 37.
Yes.
Lordships may come to clause 7.
Yes.
Clause 7, Lord, the minimum qualifying criteria that it has been given for SC/ST OBC, it's 48th percentile.
Yes.
And on the next page, if your lordship should see para 8.
Yes.
Para 8, the second paragraph, in respect of candidates belonging to SC, ST, OBC, the marks obtained in 3 core subjects shall be 40% instead of 45% for general category candidates. Here, admittedly, my lord, 6 students who have qualified in the entrance test with the 40%, more than 40% marks, and also they qualify so far as the second criteria is concerned. Now, I take your lordships to the page 69, which is the state government, which starts from page 53 and next year 6. The prospectus which has been issued by the state government. This was for the session 23-24.
Oh, 23-24.
Yes.
So is there any change in 24?
Yes, 24-25 they have reduced.
They have?
They have reduced it as per the INC guidelines.
This year we have reduced, not 23.
Earlier year, they had kept it fixed at 50% for all.
What can be done now for 2023?
No, they have already been admitted. So far as the examination is concerned, which is going to start from 25th of July. So they are not giving the approval so far as those students are concerned, because they say that 50% has to be the guideline to be followed.
So how were you admitted?
So because of the 45% criteria under the INC, 40% criteria under the INC regulation.
But you admitted students, not they allowed you to admit. Whether they were. How could you admit?
Well, that is since they were qualified under the INC rules. On that basis, they have been admitted. I will say that it is, so far as the state government is concerned, their prospectus didn't allow below 50% for any category.
That's my lord's judgment also on that. The last matter.
Where is that?
Look,
That is
on a
double
different
petition number 8986. Yes, madam. That is.
Oh, no.
That is regarding the cutoff date.
With this.
That is regarding the cutoff date, your lordships.
This is cutoff date.
And I also rely.
There also, my lord has, because their prayer was in those cases, they have admitted students or they should admit students. My lords have not given
happening in your state.
Yes, madam.
If the INC says
Yes,
that the percentile for these reserved category candidates should be this much, then why did you not incorporate that?
My lord, in 2022, first time the regulation came, INC regulation, that we couldn't got it included in this list, the guideline. But because for this year, we have made everything settle and get it in the 2024-25.
No, why did you not do that for this session, 2023?
Because the guidelines were in 22.
No, that was the mistake, my lord. They have not done. They have only done 50%. 50% they have got the cut-off mark.
So at the time when this prospectus was issued,
Yes, my lord.
the INC guidelines
were already in
Yes,
force.
that was there.
Then why did you not implement
No,
that?
they have not implemented. That is the mistake they have committed. That's why. But all the admissions are done on 50% marks, my lord.
But this is contrary to law.
Yes, my lord.
So take a decision.
No, my lord.
Your lordships may see para 24 of your lordships judgment. No, that is a different. Your lordships may see para 24, your lordships observation about this.
Paragraph 20.
4. INC regulations. They don't have a choice. It's a statutory regulation which they have to follow. The state government.
Regarding this percentile, otherwise there is no other.
Otherwise, there is no impediment. We are not on that zero or the cutoff date, nothing is.
File your affidavit.
Yes, my lord. No copy has been given to
I'll
me.
send a copy.
You will allow them or not?
Yes, my lord.
Because the exam is on 25th, day after tomorrow.
So why have you waited for so long to come?
Nothing can be done.
My lord, the notice came later on, my lord. That is the only reason because
Nothing can be done.
I will
Seek
get
instructions.
Yes, my lord.
INCO jo OP number 5, they have read but they are not served the copy. Let them serve.
Only.
we'll serve the copies today itself to all your
No,
lordships.
they are not challenging any direction of yours.
The central government.
Against the INC, there is no
relying
prayer,
on my
yes.
learned senior,
My lord, notice has to go to the
DSJ is,
university. University
right.
notice has to go. OP number 4.
Who is OP number?
Which university?
Health University, Odisha.
Forget university. You,
I will get my.
someone is appearing.
I will get.
Someone serve a copy on name also.
Exam start?
25th,
25th, then what?
Day
Nothing can
day
be
after
done.
tomorrow. Yes, ma'am.
Nothing can be done.
Will not, your
Let
lordships
it come
may grant,
tomorrow, please seek
permitters will not
instructions.
claim
Tell us.
any equity, that also your lordships may mention.
Tell us. Tomorrow tell us.
Yes, ma'am.
Seek instruction and tell us whether they can be allowed or not.
Yes, ma'am.
They should be allowed or not.
Yes.
All right.
Yes, ma'am.
Seek instructions as to whether they should be allowed or not. If they should be according to you, then we can pass order. If they say you say they can't, then we will consider passing appropriate.
You're admitting your mistake, why should they not be allowed?
Pardon, my lord.
You're admitting that it's the mistake on your part.
No, they have not added in the 2024. 23-24 guidelines. They have not given that. Added that.
Then they can be prosecuted.
No, my lord. They when I asked, they said,
Those who have not incorporated the
Yes, my lord.
statutory provisions
Yes, my lord.
concerning reservation policy,
Yes.
then they may be prosecuted also.
No, my lord. I will tell them to
Criminally.
consider. See that.
You'll see,
Tomorrow,
there is a purpose behind that.
Yes, my lord. That's why
Cannot
this year they have
defeat
done
that.
it. That was what I pointed out. That's why they have done this year. They have
Please ask
added
them.
it. Yes.
Find out also if others are there also.
Yes.
tomorrow you.
Item 48.
Millards, may I be pardoned to make one mention? The next item, that is item number 18, that was similar to item number 15, where we are challenging the validity of notification under section 168A. Millards, the similar matters are already pending. This matter can be tagged up with those matters.
So whether that matter has been decided anywhere or not in the country.
Allahabad High Court and Kerala High Court, both the High Courts have decided that issue.
And no other high court.
No.
Kerala High Court, which year? Decision of this year.
What is their view?
Both the High Courts have upheld the validity of that notification.
Then we don't have any choice. Then we don't have any choice but to. Otherwise.
Around 8 weeks. When is it posted? 9 weeks a date. On that. Similar order. The order was here. One, 132. 24. 14230 of 24. That we gave later.
Yes.
Item
Yes.
48.
We are giving time to file applications, but to delete that. In fact, we have already prepared, but the large number of cases, they have to come and file application. That is why also give us some time, at least next week here.
Which prayer?
Virus.
People are from different parts of the state. They have to come and swear affidavit to delete that prayer. Otherwise, memo without an affidavit will be at risk, man.
So, transposition of See, the arguments are over.
Practical.
Only you are.
Rights. Lordship have already, that we have,
You don't want to take a risk without the affidavit.
that is the problem.
Just one memo with affidavit, that's all.
Just memo with affidavit, nothing else. Only this portion of the prayer we want, that is the affidavit and we have prepared
No,
it
but
only.
we can record your oral submission also. There is no difficulty.
Sometimes you also know that because of.
No, everything is there.
Clients may say that we have not
Let us,
instructed.
All right.
sometime so that we can file an affidavit also.
All right. As requested on behalf of the petitioners. Learned counsel for the petitioners. And learned counsel, learned AGA representing the state of Odisha have been heard at length. Learned senior counsel representing the petitioners have submitted that they intend to, that the petitioners have been advised to delete the relief challenging the virus of so and so. Stop. They submit that they intend to file a formal application in this regard.
Should I suggest? These hearings are all over. All exercises are done. That should be reserved reserve it in the meantime, we'll file it.
Okay.
That
order has to be passed.
Once
We have two options, right? One, we can
Yes,
reserve the order.
That's right. We'll do that.
Does this matter on next Monday? In the
Meanwhile,
meanwhile,
you it on Wednesday, so that we are trying to.
Wednesday,
Wednesday.
2:00 we'll finish it.
Item number 85.
Yes.
My lord, both the appellants before lordship, the husband and wife, Lord, they have been convicted under section 302, 201.
Yes, what are your points there? We had heard you.
Lord, last occasion, Lord, there are 3 points. Because the case based on circumstantial evidence and the chain is not complete. Moreover, my lord, the motive is also, my lord, not proved. Though, my lord, the prosecution has come up with a case of the motive is there. So, blood, I have prepared a blood note.
Suppose A kills B.
My lord.
In front of C. Unless motive is proved, A cannot be convicted according to you.
No, that is there. But here in the case, there is no eyewitnesses. There is no eyewitness.
When there is an eyewitness,
yes,
to depose that the occurrence had taken place in his presence, where is the question of motive?
Yes, that is not one. But
the question of motive becomes important in the cases of circumstantial evidence.
Correct. I about all that.
So when everything is clear, then what is motive?
I will just bring.
Motive is apparent from the act.
That I may just date wise I am to 16/10/2020, my lord, the occurrence took place. 17/10/2020, my lord, FR was registered under section 302/201/34 IPC. And my lord, the trial was started in 2012 and 22/2014. The London Additional Session Judge Atwood has convicted the appellants and sentenced them to rigorous imprisonment for life and imposed additional fine of 20,000 on the appellants. Another accused, namely Prabhakar Behra, was acquitted, was facing the trial, my lord. On 20th of July 2015, the criminal was filed by both appellants before this honorable court with a delay, and the appeal was next page. The appeal was dismissed by this honorable court, and my lord, the SLP was preferred, and honorable Supreme Court has, my lord, allowed the appeal SLP and remanded the matter for fresh discussion. The London court below, my lord, relied upon the evidence of PW 1, 4, and 8, which are the nephew, wife, and friend of the deceased. I may place the, my lord, the evidence of the, my lord, deposition of the PW 1, 4, and 8 from the paper book, my lord. Page 70 in the paper book, my lord.
So, Mr. You are saying there is no motive, at the same time you are saying there is a civil dispute.
Civil dispute, my lord, it is
Regarding borrowing of
money,
not-
borrowing of money, lending of money. That aspect I will bring to lordship, that the money is not, my lord, propulsion, and nobody has seen, and there is no document to that effect. It is a case. But where the background is that the couple, the husband is a priest, wife was there. The deceased, my lord, had, my lord, extended financial, my lord, for, my lord, construction of a temple, where, my lord, the deceased was used to come from his village to the particular, my lord, place where the occurrence took place. It is 20 kilometers away. And the, my lord, the place where the worship was taken place and all that, it is accessible to all. And, my lord, many people are, my lord, the nearby villages and all that, they are, my lord, worshipping in the village. My lord, the informant, the nephew, lost the FIR. And he had stated that on 16/7/2010 at 5 p.m., the deceased elder father left our house, informing us about his going to the house of Sarat, the present appellant, and Tilotama of Kendapatna to collect money from them, which they had taken from him for construction of Bhai Thakurani temple. Thereafter, my lord, he is a post occurrence notice, he has not seen. Then kindly come to PW 4. PW page 84 of the paper book, my lord. Our 17/7/2010 at about 8 to 9 a.m., we got information that Parsuram Pati has been murdered at Kadampatna. We could know that he has murdered in the previous night by setting him in fire and assault by accused Sarat Pani, his wife Tilotana Pani, and their son Sudhakar Pani. On receiving such information, 17th, we rushed to the village Kadampatna of Bhai Thakurani temple premises. There is a small thatched house near the temple premises. The wall of that house is made of mud and the door was locked. We could see through the damaged wall that deceased Parsuram had sustained deep injuries on his head, and his body from neck to waist was burnt. Police and the scientific team arrived there. Parsuram Pani Patri was my nephew in the village courtesy. 3 to 4 days prior to the murder, Parsuram Patri had rebelled before me that he was in financial stringency, as he had given some amount to Sarat Pani and Tilotama Pani for construction of temple there.
the whole entire exercise of yours should have been confined to prove that the evidence of the eyewitnesses cannot be believed. So if their evidence, their depositions can be believed, then there is nothing. Then they were eyewitnesses. And why should we not believe them? Which is corroborated by the medical evidence also. So that is otherwise you may keep reading everything, but
I have to bring to Lordship's mind. Kindly, my note I have prepared by assistance of my associate, page 6. Page 6 of my note. By allegedly crowbar, then he burnt. It is the prosecution has developed this case.
Along with the thatch, inside the thatched house,
In this,
the
the
house has
thatched
also caught fire.
Inside the thatched house. Fire was.
So inside the thatched house has also got burnt to some extent.
There's some extent burned, but the assault was made.
Assaulted and burned.
Then burned. No eyewitness. And no eyewitness. There is no eyewitness.
And 1, 3, and 4?
But 3 and 4 are post occurrence, and they have heard that the person deceased had lent some money to the.
Not heard. Deceased had informed at his house that he is coming to the house of the appellants to collect
I am going
money.
to collect.
When he did not return, and this PW1, his nephew was informed,
Yes,
so
that is
nephew went to that place and found the dead body there.
So have you given the English translation of the depositions?
My lord, that is there. Yes.
The
FIR, that is not. But the FIR I have not done. The FIR, that is not. I will- FIR copy I will
How do you I mean, why should we not believe PW1, 3, and who is the other one? 8.
Well, only to that effect that some money was given by the deceased to the appellant.
Okay,
And-
that
and-
we are stressing on the motive. What
But-
about
yes.
that body in your house?
Yes, no. Because the evidence has come, the appellants have their own house in the village. There is some.
Just sorry for interrupting. Is it the case that you also have sustained some injuries, some burn injuries?
Well, the wife appellant has some injury. That is there in the evidence of the doctor. That is there.
PW23.
Yes.
So that is in your favor or against you?
No, my lord, that I'll bring. Once other circumstances are not, and the prosecution has not proved the chain of the circumstance. That I'll bring. I'll demonstrate, my lord. The chain is not complete, and the appellants have their own house, and it is a separate temple and the thatched house accessible to many people. And the person who died, my lord, he used to come, and there was a cordial relationship between the appellant's family and the deceased, because it is the evidence that this priest family has saved the son of the deceased by worshipping and making some puja, and they had good relation. And the deceased used to come to this place, to the village, where the evidence of the IO says this place is accessible to many persons used to come. This is the I also that in the evidence that this is accessible to all. And there is no linkage whether the persons who are staying on that night, the husband or wife, because they have their own house. It is a thatched house. Thatched house, and the occurrence took place in the same thatched house, adjacent to the temple.
Yes.
Then we proceeded to the house of so-and-so, constructed with mud walls, and found smoke coming from the thatched house of Saratapani
Next day,
constructed.
next day they went.
I, removing the jhatia mati wall, saw the burnt dead body of my elder father, and his face was stained with blood.
They are the post occurrence.
In that house, Sarata was residing with his wife and children.
He is the post occurrence of the interested witness.
Why do you say you're not staying there? Have you led evidence?
Yes, other PW2 and PW3, they have the evidence that they have their own house in the village. And it is not the case or any document, the prosecution has come up with any this that the persons who are staying with their household articles, they have also bed or anything is there. That is missing in this.
Yes.
No eyewitness, only circumstance post occurrence witnesses are there. All evidence given by the witnesses are hearsay evidence. The London trial court, they didn't while deciding the exclusive position of the appellants over the so-called thatched house place of murder, when other witnesses PW2, 3 have deposed that the appellants have their own independent house in the village. There is no documentary proof of position of
PW2 has been declared hostile.
Hostile, yes. Hostile witness also some evidence. They have to some credential has to be taken. That is not be total discard. Even hostile witness have also shared some. And there is no documentary proof of the position or stay over the thatched house. Page 41, internal page 30 of the judgment. And the all propositions made by the defense counsels were discarded mechanically. And the prosecution has to come up with the proof of residence of that is missing. My submission, rightly pointing a question. The prosecution has not come up with any proof of that the residential house of the appellants. Rather, the defense has adduced that trial court observed page 41, internal page 30.
Defense, have you adduced any defense witness?
No, my lord.
Where?
That I may to place in the impugned judgment, my lord, page 30, para 32. To sum up, all these circumstances are not consistent. My lord, lordship, the paper book, page 41, internal page of the judgment, impugned judgment, page 30. Your lordship, page 41 of the paper book, internal page 30, my lord. Paragraph 32. To sum up, all these circumstances are not consistent with any rational hypothesis of interference. Trial court has also observed that this evidence also is not. To sum up, all these circumstances are not consistent with any rational hypothesis of interference and are consistent only with the guilt of the accused Sarat Pani and his wife Tilotma Pani. There is no evidence against accused Prabhakar Behra to connect him with the murder and screening the evidence except the evidence of PW 8 and 9 that on the same occasion he had accompanied Sarat and Tilotma to the house of the deceased to collect money. The evidence doesn't show that he was conscious about the hidden intention of Sarat and Tilotma that they would cause the murder of the deceased by avoiding payment of money of the deceased. However, resist of myself from making any comments of the complicity of the juvenile Shankar Pani, the son of their appellants, with the crime since he is not before this court. On conjoint reading of entire evidence on record, the submission of defense counsel that the PWs are interested witness no motive behind the murder, no enmity, possibility of murder by other persons as the place of murder was accessible to all of the deceased. The prosecution examined impartial witnesses who have no acts against of the accused person. They have honestly stated that they have heard the motive behind the murder is apparently rupees 4 lakhs, somewhere some that 3 lakhs, somewhere 5 lakhs, 2 lakhs, that is not forthcoming. The giving and taking money and any document proof, that is not coming, that is not missing. So the the place of murder was in exclusive possession of the accused person, Saratan Trilothram. The defense has not examined any villagers to establish that were residing. But the prosecution has not proved that the person who are supposedly reside, and this honorable, the London trial court has shifted the burden to defense to prove whether you are residing or not. That is the London trial court has. So the motive is that money is missing, that is no. Exclusive position over the house also missing, that is not, some evidence is not coming, and it is accessible to so many people of the village, nearby village, who are used to concept. And also there is no previous enmity, as it has not been, because it is evidence that this family had saved the son of the deceased by worshipping puja and all that. So
and he had paid some lakhs of rupees for construction of the temple and was asking for return of that money.
Yes.
PW 1-2 has
Yes,
stated.
that state says. Also, many people have also the nearby villages, not the exclusive temple.
So there is no eyewitness.
No.
Sure.
The PW informant states about cash lent by deceased to appellant to the tune of rupees 5.
Yes, Mr. Sound.
Yes, admittedly there are no eyewitnesses.
Then
But the circumstances,
what?
that they are acquainted with each other. He had lended some money for construction of the temple, and previous night he had stated that he is going there to collect that money, so that because he had incurred some loan during the marriage of his daughter, so he went there, did not return. Accordingly, they when telephone he did not answer, so they went in search of him, and he was found lying.
Where did he go?
He went to the house of the appellants.
What is the material to show that that is the house of the...
Interestingly, PW4 everywhere stated, but no, in cross-examination, no question has been put to them that they've got alternative house. No question has been put to them. They've stated that there was a thatched house where the dead body was found. There also all these appellants were staying, but no question has been put in the cross-examination that they've got an alternative house elsewhere, or they were not staying there. There is no suggestion or cross-examination. And 106 will come to the aid, because they have to explain because from their house which is in their possession, dead body is recovered and it is stained with blood also. And the other Tilottama has got a burn injury on his head. PW 23 doctor says that she has sustained burn injuries. Very next day, and all these circumstances points for that, and no rebuttal evidence also.
This might have attempted to burn them. The deceased might have made an attempt to kill these persons.
Because they could have said so, they could have laid evidence also, that they could have taken it, they have not stated anything in their defense. In the 313 statement also, nothing has been said to them. Everything they have said that micha, only lies, they have not said anything.
But have you asked them everything?
So far as Question, not specific question.
Oh, that also Micha Katha, that you have cured his son, that also they say Micha Katha.
A polygraphy test was also conducted, Milos.
Not of this. It's a one polygraph test done of Prabhakar.
Everything is been.
Page 162. Prabhakar.
And what is the injury apart from burn injury?
No, nothing.
Plus PW 21.
No, the wife.
Injury of the
Oh,
deceased.
injured deceased. Sorry. My lord was
PW
just
21, Milos.
the doctor.
Number of stab injuries. Stab injuries.
Stab injury.
Has any weapons been seized? Any weapon been seized apart from the crowbar?
Yes,
Crowbar?
no.
Crowbar is
Crowbar has been seized. They say it's similar.
No, there's
One,
stab injuries are also there.
yes, but crowbar from this spot has been seized. Those head injuries is stated that to be through the crowbar, Milos.
Cause of death is those injuries or the burn injuries? The
Yes, sir.
stab injuries or the burn injuries?
Cause of death is opinion that
Oh, they say that crowbar had one end was cutting
yes.
in nature. Burn injuries were post-mortem in nature.
Yeah.
Burn injuries. Killed and burnt. Injuries 2 to 7, which are the stab injuries, are antemortem. And death was due to craniocerebral injuries sustained to head and brain. And that crowbar can produce the injuries. That is the opinion of the doctor.
All right, we'll see what can.
Give a translation of the FIR.
Translation, I'll give.
Yes.
Item number 19.
Oblige, bloods.
Wait, please, my lords. Annexure 1, my lords, is being assailed before your lordship. Lordship may permit me to place the Annexure 1. This is issued by the Deputy Director Mines in charge. Now, my lords, earlier the mineral concession rules, minor mineral concession rules as they stood, the Tahsildar was, my lords, the main officer. And now, my lords, after the amendment, it is now the DDM, Deputy Director Mines, my lords. Now, my lords, this is the subject. Imposing a penalty against illegal storing of sand, crushed ore, and granite boulders.
There is no appeal against this.
My lords,
There is no statutory appeal against this order.
there is an appeal.
Is there any provision for appeal?
There is a provision for appeal, but our point is absolutely, my lord, it's a point that your lordship may kindly bear with me, my lords. It's a penalty which has been issued without a show cause. So my point is violation of principles of natural justice. No,
That could have been done by the appellate authority within 2 days, 3 days, 2 weeks.
So lordship,
Order which has been passed by the original
the
authority.
difficulty in appeal would be my lord, I bow down. The difficulty would be, my lords, in appeal we have to deposit 100%. Even if the, my lords, and these are, my lords, these are all, we have paid the royalty. If your lordship permits me, my lords, we will demonstrate, my lords, already royalty has been paid in this. Already paid. And there's an endorsement by the Tahsildar that the royalty has been paid. So, unless after paying the royalty, he doesn't give us an opportunity. Had he given us an opportunity, my lords, we would have showed him the papers. He comes, my lords, these are ongoing transactions. I am, my lords, executing a public work. I am executing the most difficult part of the tunnel work in the Balangir siding, my lords. And my lords, the scope of the work is, my lords, extremely, my lords, it's a very difficult terrain to operate, my lords. And
Yes, who is for the state?
I'm for the state, your lordship.
So then he appears to be right that no notice was given.
Appeal provision is there, your lordship. Let him go on appeal.
No, but it is apparent from the impugn order.
Why does the order say that you have admitted your fault and agreed to pay the penalized amount?
no, this was the project manager. He was not authorized, my lords.
No.
Threatened for stopping.
Then you will have to file for appeal.
No, why does he say? Have you stated somewhere?
No, my lords, that he was, yes, we have stated somewhere. We have stated, I'm grateful, my lords. Page 13D, my lords. Page 13, we have stated, my lord, that he was coerced. We have signed under paragraph, my lords, paragraph D.
Then where is the question of principles of natural justice?
Further, because it's well said.
Lordship, the details of penalty.
Your lordship may kindly, the fourth line, that the opposite party number 3 intimidated petitioner's employee who does not have any authorization to sign on behalf of the petitioner any document in connection with tunnel project works and further represent the petitioner in any manner into signing some document and false.
No, why are you not reading Annexure 1?
Annexure 1 itself. Yes, ma'am. This is the explanation in Annexure.
No, and Mr. Palit, one doubt. This is not regarding unpaid dues. This is a penalty for some action done by you.
Yes, penalty.
Yes, penalty. It is. You were saying you made payments. That they are not saying that this is not for unpaid. Unpaid
penalty.
amount.
They are imposing a penalty. That is exactly the point. That's exactly the point.
Apparent provision.
No.
You can go there.
Penalty, my lords. Penalty is for non-payment of royalty. That is how they have charged. Your lordship may see the breakup. Your lordship may kindly see the breakup. Royalty and additional charge.
See, we will not go into that because the order says that you have admitted your fault.
Yes, your lordship.
And agreed to pay the penalized amount. You want us to quash it on the ground of violation of principles of natural justice.
The employee was not authorized. That's what we have stated on affidavit.
You remove him.
My lords, his admission may not bind us because
yes, this order was passed on 10/5/2024.
Yes, your
my
lordship.
lords, 10/5/2024.
So this person has cheated you.
No, he has not
Project
cheated.
manager.
He under coercion.
Under coercion. That cannot be seen by the record.
We have stated, my lords.
Sorry.
The impugn order clearly states the circumstances, Your Lordship, the first paragraph itself. As per the subject matter, I'm to say that the vehicle, highway truck loaded with sand and boulders, 4 numbers, with illegal storing of minerals such as even the amount has been given, sand, granite, boulders, crushed ore has been seized by the undersigned on dated 13/3/2024, Your Lordship. At your crusher point in Adangar, both without having authentic papers with the vehicles. The vehicles also didn't have any authentic
Lordship,
papers.
kindly come to page
You also
59, my lord.
admitted your fault and agreed to pay the penalized amount as fixed by
Page
the
59, we have already paid. Page 59, my lords. This man was not even aware of the details. Page 59, Your Lordship may kindly come to annexure 20, page 59.
You file an affidavit tomorrow
My lords.
that you have filed criminal case against the project manager and you have dismissed. Because it's a private company, no?
Well, we are public limited company.
Huh?
We are
Yes.
a public limited company
Public-
executing a public
Yes,
job.
yes. You are saying that project manager was not authorized. And because he was not authorized, he did it.
No, he was not even aware.
Huh?
He was not even aware.
You say you have admitted that you are fault.
This is the explanation that we have given. The petitioner's employee does not have any authorization to sign on behalf of the petitioner any document in connection with the tunnel project works and further represent the petitioner in any manner into signing some document and falsely claiming in its impugned notice of admission of fault by the petitioner agreeing to pay penalized amount. Thus, the impugned notice suffers from grave illegality. But the
Therefore,
fact remains that the notice itself is manners in stark manners on the face of it that it's a penalty without show cause.
All right. Which power has been exercised?
That is also not
No, we are
mention of the power. No mention under what provision he has done.
Is it your submission that it is beyond jurisdiction, no power?
My lords, he has exercised power under 51.
Huh?
51(4) would be the
51(1).
51(4).
No.
Not penalty 4.
Oh,
51(1) is fixed. 51(1).
or where you agree in writing. So you have not given anything in writing. Because it says where the offender agrees in writing to compound the offense.
Yes. The 51(1) is not probably the.
No, 51(1)(4).
Yes. Yeah, 4. Whenever the person wins without any lawful authority, any mineral from any land, the Tahsildar or mining officer or deputy director or divisional forest officer, as the case may be, may recover from such person the mineral so won, or where such mineral has already been disposed of, the price thereof, and may also recover from such persons rent, royalty, or tax, as the case may be, for the period during which the land was occupied by such person without any lawful authority. This is in terms of mallards similar to section 21(5) of the Minor Mineral Development and Regulation Act, which mallard, there are a lot of cases, mallards, Goa Foundation and all those cases were on that section, mallards. Here, annexure 1, if your lordship comes to annexure 1, this is the tone of the mallards, order. As per subject, you have also the details of the penalty with compounding fees is given below. For boulders, rupees 3,51,000 royalty and additional charges, 35,160 district mineral fund, 17,580 environmental
whatever submission you are making, you could have made that before the appellate authority.
Lordship may give me the scope. Lordship may give me the scope to make that mallards
do that.
Mallards. Lordship may and waive the deposit. At least the deposit may
Give
be.
us the jurisdiction.
That jurisdiction always is there, mallards. If it's a question of violation of, or I may be permitted to raise this point at the threshold to be decided, mallards. That observation would.
Mr. Palitan, Senior Counsel. The petitioner in the present writ application has put to challenge the communication dated 10/5/2024 issued by the Deputy Director of Mines bracketed IC, Controlling Authority of Minor Minerals, Kandamal/Nayagar/Both, whereby a penalty of rupees 31,26,041, whereby so amount has been imposed upon the petitioner towards penalty, and compounding amount as the petitioner's vehicle, namely Highway truck, was found loaded with sand and boulders with illegal storing of minerals. First off, Land Council, next Land Council appearing on behalf of the petitioner has submitted that the petitioner has agrees that the petitioner has remedy of appeal under the provisions of Odisha Minor Mineral Concession Rules 2016. Post Office seeks permission to withdraw this writ application with the liberty to raise all the points which have been raised in the present writ application before the appellate authority. Post of this application stands disposed of accordingly with the comma with the liberty as sought.
Grateful, ma'am. Only this, ma'am.
Mr. Pallit,
Till then,
Mr. Pallit, one is till then. Other thing is the other thing you were asking about waiving that amount. If you make it clear, you may face difficulty. Otherwise, you try your luck. Think about that and
till
tell
then,
That we made it so. Yes.
no, I was only suggesting, my lords, if subject to whatever your lordship says, my lords, till he decides the appeal either way, the demand may be kept in abeyance. Only that little concession your lordship
So
made. It's an ongoing work, my lords.
High Court is the appellate authority under the rules.
No, I don't say that. I'm only that slight concession. If your lordship grants, my lords, I'll be deeply obliged. Deeply obliged. Till he decides.
These are thoroughly illegal orders if we pass. All right.
My lords, till he decides. Till he decides the interim application at least. At least till he decides the interim.
Again, the petitioner shall be at liberty to
File an,
raise all such plea which may be available.
I'll file an interim application that may be considered.
Never.
Item 20.
We should understand our limitations first.
My lords. No, but I've been hit on the face, my lord, by an order without any notice.
That is the duty
And your
of
lordships
every,
have been
Mr.
extremely
Pallet,
loath to, my lords.
that is the first duty of every court, that the court must identify its own jurisdiction.
Grateful, my lords. I bow down, my lords, but your lordships have always consistently, my lords,
Yes.
turned down such penalties imposed without notice.
Yes.
Grateful. Grateful.
Item number 20.
May I please, Lordship? Lordship. In this writ petition, I have the limited prayer, Lordship, that is initiation of tender affairs with wide participation and involving of the wide contractors, Lordship. Lordship, NSC floated three tender notices, that is under annexure 1, 2, 3, Lordship. That is 15/12/2023, 2/2/2024, and 16/2/2000.
No, what is your grievance? These were issued in 2023. Then what happened?
Lordship, work order has been granted to the registered contractor of the NSC only. But according to the section, Lordship, rule is there that is not limited to only to the NSC contractors. That is
What is NSC?
contractors of
Notified
the
area
NSC,
council.
Lordship.
Notified area?
Council, your Lordship. Notified area council. Notified area council.
So that means annexure 3, clause 2, you are agreed by that? Bids are invited from eligible contractors registered with Kasinagar NSC. That is your challenge.
Yes, Lordship. According to the municipal rules, that is not valid.
Just see. Kasinagar NSC, any other ULB in or outside the district of the state. And engineering firms of standing as per rules 353, 354, 359.
But Lordship, they have selected only the NSC contractors.
Selection is, had they restricted, had they made any provision that only they shall be selected? What is NSC?
And they have received.
Something registered with the. So you explain how that clause is liable, I mean, not sustainable. You tell us, then we can see why it is not sustainable, because it on the basis of it, it looks to be all right.
So if there are 5 contractors, 2 are not NSC contractors, 3 are NSC contractors, all of them participate. And in that process, 3 are selected, who are found to be NSC contractors. Can you challenge that on the ground that only NSC contractors have been selected?
Lordship, they have received the application of only the NSC contractors.
No, have they disqualified the others or not received at all?
No, Lordship, I haven't received anything. That's why my grievance
You have
is
not
that.
received. Who are you? They
Means apart from that NSC contractor, they have not received any application from other contractors.
Received or accepted?
Sorry, accepted, Lordship.
This is what we are saying. Whether you had participated or not.
No, I am not participated.
Then this is a PIL?
No, this is not PIL. Lordship, I am the councillor of that area, chairperson and councillor of that area. My grievance is that after.
It is very difficult, madam.
Chairperson.
You are councillor of that area. And that council is doing all these mischiefs.
No, Lordship.
No.
And my humble submission.
Your grievance is against the council.
No, Lordship. My grievance is work has been or work
No. You are challenging the action of whom? The executive officer. The executive officer could not have done without the consent of the council. Mr. Dale, am I wrong?
That's correct.
So, I mean, we are not able to understand how it could happen.
Lordship, I am.
You are the chairperson or one of the councillors?
I am the chairperson and councillors of that locality.
Oh, so all of you have challenged?
Yes, Lordship.
Who has given the
and my humble submission is work order has been granted on 14/3/2020.
who has granted?
That is Lordship NSC.
NSC has granted.
Yes, Lordship.
NSC is challenging. We are not able to understand this situation.
You're not the chairperson, you're the vice chairman. Vice chairman and 2 councillors.
So this dispute is between the vice chairman and chairman. It's an internal dispute. Are you a bidder?
No, I am not the bidder, Lordship.
Then you don't have any locus standi.
Lordship, in this case, the work order has been given to them on 14/3/2024, but that has not been completed till yet. That's why I put.
No, madam.
43 and all 3 confined conditions.
Nothing.
Oh.
See, you are fighting amongst yourself. And you have come to the High Court. As you wish.
See paragraph 5.
Yes, Lordship.
No, madam.
This you can approach the government, not here. The other, I mean,
Whatever.
we should not advise you. There are other avenues available to you. Take advice of Mr. Dole.
Otherwise, every matter will come to the High Court because of some fight between chairman and vice chairman. As you wish. Maybe
My representation also pending before the collector.
that we will not. a representation. The petitioners
Lordship, then kindly permit me to withdraw the
and
petition.
counsel appearing on behalf of the petitioners after some arguments seeks permission to withdraw this writ application. Without this application is dismissed as withdrawn. Without text. We have not gone into the merits of the case. The party shall be at liberty to raise issues which have been raised in the present writ application before appropriate forum. Forum slash of.
Note 21.
Oh, bless Lordship.
May I please, your lords. The petitioner who is a successful bidder miller, he qualified in technical bid under the 5 technical constituted committee. His price bid was open miller and he stood lowest 2.70 the estimated cost miller. The tender authority and committee as per the OPWD code 6.3.15 recommended for approval miller. And when the recommendation was made, after recommendation, the one line they cancelled the tender miller. And miller, they invited retender miller. And miller, your lordship, the cancellation of tender miller, your lordship, and connected matter that considering the division bench order of division bench, please to issue notice and fix for 30th. What is the miller? What the reason miller? Your lordship know that the natural sources and all judgment regarding Article 14, they must be recording reason miller. In recent miller and judgment, I came to miller the cancellation of tender. The court can was the cancellation and miller, including retained of the Honorable Supreme Court regarding miller the cancellation on the stage of cancellation. Once you open and it is this has been done a particular miller keeping a particular bidder, your lordships and your lordships and here miller your lordship has not granted interim order only to keep same miller just before miller election they have all cancelled other which is recommended are cancelled, your lordship. But the Supreme Court judgment regarding this.
Cancel after election.
No, before election, miller. Just what recommended miller and OPWD code. There is a codal provision in tender that one it is recommended on 6.3 point of OPWD and the same OPWD code provides when they are selecting the lowest bidder should be accepted. Should be accepted that word.
Find your affidavit, you will see.
Yes, your Lordship.
Maybe on same date, miller. Here is a retainer, miller. That's miller interim, miller. That time.
Which day?
30 days.
13th.
Yes. And one order, same situation. This on.
No, but have you served a copy?
Yes, I've already served. Same one. But if it for interim, miller, not to finance subsequent tender, they invited miller.
No.
Maybe tagged along with this. Oblige.
Item 22.
22 same also. They have written. It is. So they invited in 6 crore excess also.
Item 23.
All 37. You come up on 37, you prepare your affidavit.
13/7.
37.
38.
37.
23.
Let it come, try.
I'll try.
You don't try.
I'll try.
May I please? The petitioner has filed this petition challenging the rejection of his technical bid on the ground that he has not qualified in respect of the similar nature of work he has done. Similar nature of work the petitioner has not been done. For that reason, his technical evaluation has been rejected. My lord, your lordship may see annexure 2, page 14. The same tender was floated and which was the technical annexure 2, page 14. My lord.
Yes.
My lord. The first evaluation was made on 19/2/2024 and the said tender was cancelled since it is single tender. Only I and the another person has participated in tender. My tender was rejected on the ground. The self-same document I have submitted, my lord, page 15. My serial number is 2, my lord. One is Trinatha Construction and I am Pachaspati Ghosh. Minimum period of contract agreement, lease deed of equipment and machinery is not achieved as per deletion eligible criteria 125C and 10 IV. Thereafter, again they floated the same tender by Annexure 3, page 16, my lord. The same work. Thereafter, I participated, and this my tender was rejected in the technical evaluation, page 66, my lord, Annexure 5. Page 67 is the relevant portion. 3 persons have participated. Same Trinatha Construction. My serial number is 2 Bachaspati Ghosh. Well, similar nature of works not
Yes.
Similar nature of works not achieved as per deletion eligible criteria clause number 125F. Well, I have submitted the same document in the second tender. They are disqualifying me to accommodate other persons, only not to give the work to me by different pleas, my lord. Your lordship may see the 125F.
What was the work?
Well, I have submitted the construction of bridge, my lord.
Construction of bridge. So you want some other bridges to collapse?
No.
You don't have any experience.
Yes, my lord. I have experience. I have given. I have given. This same authority is allowed.
What is 125F?
Relating to similar nature of work.
Page 47, your lord.
Your lordship may see again in another tender I have submitted for bridge also I have submitted before the same authority. They have allowed me in technical evaluation. They have allowed me. Next annexure page 69, your lordship may see.
Yes.
The same authority is allowed my tender in respect of another tender I have submitted on the month of.
No, in case you have not submitted that document.
Yes, I have given in this annexure also in this case, ma'am.
Bridge means what bridge? What kind of bridge?
Small bridge in the state highways, my lord.
Small bridge in the state highways.
Yes, ma'am.
So you had earlier constructed bridges on the highways.
HL bridge, ma'am. High level bridge.
High level bridge earlier you had constructed.
Yes, my lord. One ongoing work is going on, which will be completed by 35, and one work I have completed.
No, it must be completion.
It must
not going on.
We have come disqualified
No.
because works are ongoing.
That is the criteria, my lord. That is the criteria. You have to submit relating to the ongoing works as well as the completed work.
So let us see 125. Where is 125?
Page 47. your lord.
125F, your lordship may see.
Page 47.
Your lordship. Page 47.
If it states to be eligible for qualification.
Your lordship may see. Submission of the required information on their available bid capacity at the expected time bidding as per clause 14.4 schedule G, the report showing the value of existing commitments and ongoing works for each of the works should be filled up by the tenderer, and certificates of each work should be from the engineer in charge, not below the rank of executive engineer / superintendent engineer, which is mandatory. If it is nil, then nil report signed by the tenderer must be furnished. Next F, my lord. Information regarding experience in similar nature of works in schedule D1 and list of works in progress in schedule D2 as per the clause number 14 with scanned copy of experience certificate in form G for match issued by the engineer chief, not below the rank of executive engineer. Your lordship may see clause 14, madam.
Clause 14?
Yes, madam. Page 33, madam. There it has been classified. How it will be, I will submit the detail, madam. Relating to the ongoing work as well as the completed work.
Yes.
Clause 14, my lord. Roman 1. Each bidder is to submit along with bid a note regarding the experience of the construction of bridge work. Name of the road, estimated cost, total length of road, major item works. Everything has been mentioned
The bidder
there.
should qualify the criteria of similar nature of work.
Yes.
As mentioned in contract data, failing which the bid is liable for rejection.
Yes, madam. That is there. I have submitted all these documents as annexure 4 series, madam.
So what is the nature of this work? High level or low level? Construction of
high level bridge. High level bridge, madam.
Okay, all right.
Next one is 61, page 61, construction of high level bridge ongoing work which will be completed by 31/5/2024.
File your affidavit.
Yes, Your Lordship.
2 weeks.
The earlier tender was rejected because it became the first time single response tender, Your Lordship. Because there were two after his disqualification, it became a single.
If your a tender can be cancelled for so many reasons.
Yes.
Earlier tender was cancelled for one reason. Now in the second tender, if you participate and if there is 5 defects, your tender can be rejected on the ground of 1 defect only.
Yes, madam.
Now second time if you participate,
Yes.
every evaluation is independent process.
Yes, madam. But intentionally they are harassing me because
Intentionally we don't know.
First.
And intentionally see. After all, it is they who have to decide.
yes, madam.
All right, because they have to
Madam,
get the work done.
If the calculation sheet they have to submit how they have awarded the mark to me.
And
That
we
has
just
not
have
been
to see
disclosed.
that illegally, they have not.
Yes, madam. My submission is that. In each time they are.
We will see later. Yes, 2 weeks.
Item number 24.
That's in item number 24. But the committee of chief engineers has already taken a decision and recommended to the state government, and government will take a decision in the matter. So they prayed for 4 weeks time. Grant some time so that decision can be taken.
Let us see the order first.
Page number 13. Operative paragraph 9. Regarding payment of
Paragraph 10. In view of this matter, the order impugned dated 25/21 annexure 1 cannot sustain in eye of law. The same is liable to quash and is hereby quashed. The matter is remitted back to the OP number 3 to reconsider the same in the light of the judgment in case of Raghunath Sahu and pass approved by affording opportunity hearing to the petition in accordance with law. So now, this case has been referred to the committee of chief engineers. Now they have examined it and recommended to the state government for compliance. For some more time. On 15/7 only they have done it.
We are initiating contempt proceeding. Have you filed any reply?
No, sir, I have received the instruction. 20th they have taken a decision. So that's why I was praying.
Therefore, they have, after having committed contempt of court, just to avoid the process of the contempt proceeding, they have done something. So let them be punished first. Who was to pass? Who was to initiate? Who was to pass an order?
Yes, sir. It was remitted to the OP number.
let the OP number 3. Chief
OP
engineer.
number 3.
Yes.
Based on the file your so far.
Yes.
3 weeks time is allowed for OP number 3 to file his so-called reply as to why contempt proceeding be not initiated against him and he be not punished for intentional disobedience of this court's order dated 14/7/2023 passed in WPC number 22020 of 2023. So next, the court is prima facie satisfied, based on the allegations made in the contempt petition and the submissions advanced at the bar, that there has been intentional disobedience of this court's order. Yes.
Item number 25.
Mr. Samantray, only
Yes.
4 or 5 persons.
No, so I won't say.
Once they are sent to jail,
These
the
things will
things
set
will
right.
improve.
Yes.
because I was trying.
Right, I want.
So far, I've been trying. Now, they are not ready to mend their ways.
Yes.
So, we'll make them
Yes.
mend their ways.
Item number 25.
Please, my lords. My lords, I just need 2 to 3 days to do a little bit more research on this. My lords, your lordship had
I
asked.
requested on behalf of the appellant business matter on. Yes. 1 week.
Item 26.
1 week, but.
Item 26, 1 week time for substitution. Mal. 1 week time for substitution. When we had died.
Yes. Mr. Who's there? Mr. Samantra or Mr. Khuntia?
No, Mr. Kutia.
Item 26, yes. Mr. Khuntia, learned additional government advocate, prays for one week time
My lord.
to take steps for substitution of respondent number 1 in the writ appeal. Yes.
27.
So list the case. 1 week after 31, you can list 31.
And 27, your lordship issued notice in the question of limitation on 21/5/2024. Reported that item delivered.
Item delivered last time also we had adjourned asking the registry to check if any counsel has appeared. What is the period of delay and are similar matters pending before this court?
Yes, madam, this is the matter regarding that pension of block grant employees.
Are you aware on which date they are posted to?
One matter, the leading matter will come on 25th. Your lordship, because in this matter, may fixed to next week.
Delays only 40 days. Delays 40 days?
Yes, yes, ma'am.
This IA has been filed, this interim application number 469 of 2023. This interim application has been filed for condoning the delay of 40 days in filing the writ appeal. Full stop. Postal tracking report indicates that the not this case, that case has again gone up somewhere. So let me just check item delivered. So we can't rely on the note also. We have to see what is there. Item delivered to ABC addressee. All right. Item has been delivered to the addressee on 3/6/2024. None appears for the respondent opposite party when the matter is called. None had appeared on sole opposite. None had appeared for the opposite party on 9/7/2024. Full stop. Considering the explanation for the considering the explanation for the delay in filing the writ appeal, and we consider it expedient in the interest of justice to condone the delay of 40 days in filing the writ appeal. The IA is accordingly allowed and disposed of. List the case on 23. 23 is today. So when are the connected matters? Today is 23rd.
On 25th.
25th. List the case on 25/7/2024 when similar for admission along with similar matters. Number 8 ଗୋଟେ number ମିଳିବ? One number. You give it, otherwise.
Item 28.
28, my lord, as per my lord's direction on
Return undelivered.
16/7/24, I have served copy today. So, Mr. Samal requested me to make a mention for next week.
Okay.
I have served the copy today.
Mr. R.N. Mishra, learned additional government advocate, submits that that as per order dated 16/7/2024, the copy of the appeal memo has been served on the learned counsel. Appeal memo.
My lord. Along with I for limitation.
Huh.
That
That he has served, order I was saying. Has served a copy of the IA along with appeal memo on the learned counsel who was appearing on behalf of the respondent in the writ application today.
My lord, today.
Hence list the case. Is it connected to any other matter which is posted to any particular date?
Nine.
Achi? Or list the case on 30/7/2024.
My lord, who was appearing for the writ petition. Not
For the writ petitioner.
Item 29.
What is his name?
GP Samal.
GP.
GP Samal.
You can indicate his name. On Mr. GP Samal, learned counsel who is appearing for the writ petitioner in the writ petition, which has the order in which has been challenged in this writ appeal. List the case on 30/7/2024, indicating the name of Mr. GP Samal, learned counsel as counsel for the respondent.
29.
I may please your lordship, I am an virtual member. I may indulge your lordship's attention that of your lordship's order dated 18/7/2023.
Yes.
Where my Lord Justice Savitri Patra was a party while passing the order. 18/7/2023, ma'am.
Which item?
Item 29.
18/7/2023.
18/7/2023. Before I place the matter, let me place the order dated 18/7/2023, ma'am. Paragraph 3. Mr. Panda, Learned Counsel has pointed out that the respondent...
No, why did you point out? I thought you wanted me to recuse.
No, not that.
So if I...
Your lordship was in division bench ballot, again your lordship is sitting in division bench. There is no risk. If your lordship want, I have nothing to say. But I feel it was before a division bench, again it is before the lordship ballot.
So what is this about?
Challenging this order. I am not challenging this order. Your lordship has passed the order in writ appeal.
What for the matter has come?
Yes, ma'am. I can understand if I can challenge your lordship's order in a writ appeal, I can understand your lordship is not supposed to hear. But here,
what for the matter has come today?
matter has come in orders, but I think if your lordship will permit me, I can argue and complete the matter.
Let us see what for the matter has come today.
It has come for orders. Or lordship fix any date.
Just a minute. This appeal had been dismissed for non-prosecution on 29/11/2023. So that order is more relevant than the order in which... Thereafter, it has been restored.
Yes.
And it has been adjourned. So no particular reason why it has been listed for orders.
No.
There's an interim order. Orders. Everything is there. Counter affidavit.
For stay for further.
That interim application was not entertained, no interim order was passed.
Then it will come for admission.
Yeah.
Admission.
Keep any day, my lord, I'm ready.
All right.
List the case for admission on 6/8/2024.
Bow down.
Item 30.
You are there with him. You are Mr. Ponda. You are Mr. Misra. Your name is not there. That's why always I get confused. He is Mr. Mishra, you are also Mr. Mishra.
I'm Rajiv Mishra.
Rajiv Mishra, all right. Not elected. No. Rajiv Mishra along with Rajiv Mishra.
Item 30.
Item 30, my lord, notice was issued on 19/10/23 on limitation, a delay of 105 days.
Lord, here I am appearing for the sole respondent, my lord. Your lordship must be remembering I was moving the contempt application. Your lordship asked me to just remind that this man is 80 years, around 80 years old man, my lord. He is, my lord, waiting for the result of the order passed in the by the honorable single judge, my lord. And
So we are
this has
already-
been challenged. This is a case, my lord, where the principle has been decided.
First, we have to condone the delay and then decide. 106 days.
Yes, your lordship can condone the delay. I have no,
Yes, this
but I pray your lordship may fix up a.
So, is your similar order also same answer?
This is a covered matter by the honorable apex court. It's
Very
covered
good.
matter.
Now you point out. Yes.
My lord,
My lord,
this relates to work charge. My lords have already fixed to 22/8 to hear on merit. The principle 22/8.
22/8, that other case is there, my lord. This is otherwise covered by the decision rendered in Narsu Pradhan case, my lord, Narusu Pradhan case, my lord, which has been, my lord, upheld by the honorable apex court. And following that, many orders have been passed and they have complied in so many cases. And but these two cases, they have filed preferred appeal, my lord.
But so many cases are pending.
Yes, my lord, some
If
cases they have
we
filed.
decide your case, then all those cases will be guided by this decision in this case.
Yes.
So that is
But
the difficulty.
that is guided by the my lord, judgment rendered in Narsu Pradhan case, my lord. It's not a new case.
That is exactly our case. Narsu Pradhan case is not applicable. That is our case.
That is. Let them argue that, my lord. I will also place your lordship how that is.
So you want us to decide this matter
By Saturday.
My lord, any day your lordship may fix up, my lord.
tomorrow?
My lord, let them serve a copy of the appeal memo so that I can get prepared here.
Copy of the appeal memo be served on Mr. When will you serve?
My lord, today also.
On Mr. Mishra, learned counsel appearing for the respondent in course of the day. List the case. That is by Saturday. Keep it before that.
Since the other matters are posted to 22/8, my lord, your lordship can post it to 22/8.
Or
So that,
we don't have any problem.
List
We can just hear it tomorrow.
my lord, as your lordship wishes, my lord, as your
the
lordship
case
wishes,
for
my lord.
admission on 22/8/2009. Accept notice or-
Accepts notice.
We'll accept notice, we'll hear it that day. Acha, admission, in the writ appeal, right, Mr. PK Mishra, learned counsel, accept notice on behalf of the respondent. List the case on, a copy of the appeal memo we served on him in course of the day. List the case on 22/8/2024 when similar matters, gotte number kuantu, one number.
432 of 2022. Writ appeal number 432 of 2022.
That is the leading case.
22.
22. When similar matters, WA 432 of 2022 and batch are posted. Yes.
Item 31.
May it please, your lordships. My lords, this is an application for condonation of delay. The order was communicated to the institution on 22/9/23. We were the opposite party.
Whether institution was a party or not.
Yes, my lords, institution.
Whether
was a
the
party.
institution was represented or not.
It was represented.
Only. When was the order passed?
The order was passed on 9/8/23.
So where is the question of communication? If it was passed in the presence of learned counsel, then when was the order communicated?
My lords, 9/8/23, we have filed it on 14/10/23.
More like
1 month, 5 days.
issue.
Notice, I have one. Notice had been issued.
Notice and limitation was issued by your lordships. They have not appeared, my lords.
Will be allowed, but you write on The AD came back or the postal recusal? How is it? What is the order? 16.7. Acha. None appears for the respondent when the matter is called. None had appeared on 16/7/2024 for which the matter had been, no, none had appeared on 9/7/2024 or on 16/7/2024 for which the matter had been adjourned twice. The one you wrote earlier, write it below that. Today, when the matter is called, none appears for the petitioner. It has been reported that no counsel has also appeared on behalf of the petitioner. It will be, sorry, opposite party respondent. Heard Mr. Milan Kanangol, learned senior counsel for the appellant, considering the reason explanation offered for the delay in filing the writ appeal. We are satisfied that it will be expedient in the interest of justice to condone the delay in filing the writ appeal. The delay is condoned. The I is allowed and disposed of. We have to issue notice then. Writ appeal issue notice of admission on the respondent by registered post, speed post with AD, returnable within 6 weeks. This is the case. 8 weeks को date दे दिया हमको.
Obliged, my lords.
Because this shall be filed within a week.
We are praying.
Yes.
We are praying for stay of the honorable single judge's order.
I are listen to notice the operation of the order dated 9/8/2023, passed in writ of WPC number 13317 of 2016. What is the exact direction in that order?
My lords, he has asked us to absorb the petitioner in the before him in the institution, my lords. We have no need for any further contractual.
Okay. Shall remain stayed till the next date.
Obliged.
Item 32.
Obliged.
Item 30, notice has been issued on the question of limitation. Some similar matters were also writ appeal dismissed on the ground of limitation. Those matters were challenged before the Honorable Apex Court. In those cases, notice has been issued. So this case can be posted after some days after disposal of that.
Yes, because the delay on the 7.
This is
107 days delay.
in this case more than 500 days delay.
1,000.
That COVID
That
period.
COVID thing will come, acha.
Yes, my COVID period will be extended more
Then
than
it will come to 500.
500 some days.
Okay. So if matters are pending to the Supreme Court, we can keep it.
This is regarding regularization of ULB teachers, my lord.
No. These matters are pending, consider because the.
Where is this pending?
So your lordship said that is pending for the Honorable Apex Court?
No. Which has been remanded.
No, one matter has been remanded. This matter is pending, my lord.
We know that. Because one was remanded, that is why the Apex Court has kept this case for consideration.
Yes,
which is that matter which has been remanded.
But that I cannot say that matter. One
That is
matter.
very important.
Yes, ma'am. Then your lordship fix it to next week. I'll get that instruction. So that this matter can be tagged with that case.
Exactly.
Yes, ma'am. That matter.
On prayer of Mr. M.K. Khuntial and an additional government advocate, list the case on 37/2024.
Item number 33.
In item 33, your lordship issued notice.
Nobody has appeared.
Item report that item dispatched. Nobody.
Item dispatch, then we have to wait, calling for a fresh report.
Well,
In view of the report of, in view of the postal tracking report, which indicates that item has been dispatched, this is the case on 6/8/2024. In the meanwhile, the latest postal tracking report may be downloaded by the registry and tagged to the file.
Item 34.
the 34 also notice issued.
Return to sender.
Then we have to take fresh steps, madam.
Yes. In view of the, I notice, IRL account, notice issued to the sole respondent has been returned
May I
unserved.
submit, madam?
Yes,
You'll also see there are 4 matters.
4 matters.
Madam, in first case that I have to take fresh step. So for other cases are concerned, madam,
Item bagged.
bagged.
I think third one sufficient. Which? Okay, okay. 37. So why was it listed over? We mentioned this. All right. So first one and last one, you have to take steps.
Madam.
No, last one also
No.
we can keep it for postal tracking.
Yes, madam.
Right?
Madam.
So first one, Lekhantu, as notice has returned unserved from the sole respondent, comma, Mr. M.K. Kuntia, learned additional government advocate for the appellant, raised for two weeks' time to take fresh steps for issue of notice on the respondent. Unutilized court fees may be utilized. This is the case on 30.
Madam.
You'll 37/2024 along with the connected cases. Argudare need not pass any order.
Madam.
Last one. WA 750 of 2024. List the case on 37/2024. In the meanwhile, registry is directed to download the postal tracking report and tag it to the file. 37/2024 with the connected matters. Are there other matters or these are the only matters?
These are other matters are there also.
Okay. Anyway, these have been tagged together, so they'll come.
Well.
Yes.
35.
Stay.
Your Lordships, may I take your Lordships to Annexure 11, which is the concerned Supreme Court order, page 142. 142. May I place the order, Your Lordships?
Yes.
We've heard the learned counsel for the parties. One of the issues raised before us and admitted by the private respondent is that the basis for the judgment of the division bench was something which was never urged before the learned single judge. The subsequent development is that the endeavor of the private respondent to get a direction from the tribunal for his appointment is now pending before the learned single judge, and the orders of the learned tribunal have been stayed. Thus, in a sense, the whole issue is at large. We are of view that the additional pleas being raised for the subsequent development should result in the order that the impugned judgment of the division bench dated so and so on order says so and so in the review petition is well as well as the order dated so and so of the learned single judge be set aside, and the matters be also tagged along with the petition filed by the appellant being FAO number so and so that a fresh look is given by the learned single judge dealing with all the pleas which have now been raised by the two private respondents. Now, Your Lordship, a little brief facts is that we have two people who are actually saying that they have
So
been,
this matter has come for what? Today.
notices have not gone till now, Your Lordship.
Notices have not gone.
If Your Lordship's,
Notices will have to go.
yes.
Why are there so many adjournments?
They have been similar arguments to admit and issue the notices, and then it has been adjourned. Then last day it has been adjourned because we were not there.
No, last date it was adjourned because Ms. Guman Singh stated that the case
Yes.
will be argued by Ms. Sahu, who is not available.
I possibly cannot argue without her, so that's the reason.
All right. Come for orders, okay. So there is a delay condemnation petition?
No, Your Lordship.
Then it has to go for admission. Why is it listed for orders? The section people are confused. Why is it listed for orders? That is why we are asking. If there is no delay condemnation petition, why is it listed for orders?
No delay application.
No, stay before uncommon. Yeah, good. Let's issue notice to the just a sole respondent or the state?
Statement shall take copy
Yes,
and the
issue notice of admission to the
5 and
opposite
6 will
parties.
Also,
5 and 6, no, 1 and 6. 1 and 6 we have to file requisites probably.
1 and 6.
Yes. Mr.
Rest the statement.
R.N. Mishra, learned additional government advocate, accepts notice on behalf of respondents 2 to 5, full stop. Requisites for issue of notice on respondent 1 and 6 by registered post / speed post with AD. Returnable within 6 weeks, shall be filed within a week. List the case on 17/9/2024.
36. Thank you, Your Lordship. Lordship, it's a fresh matter, my lord. There is a delay of 7 days, my lord. And my lord, I see that there are caveators. I'll file copy, my lord.
So copies of the IA have not been served?
No, my lord. Even the writ appeal has not been served, my lord. I just saw it.
I'm appealing for the caveator in this case, my lord.
And the other,
My lord, only four private parties are there. If my learned.
So 4 days, you can't have any objection, Mr. 4
even
days.
if you have any
7 days.
Unless I get to know the copy, my lord, what do I want?
4 days. So even if you get the copy, what objection can you have? 4 days.
All right.
So we are condoning. This IA has been filed for condoning the delay of 4 days in filing the writ appeal. Sorry, 7 days.
No,
7 days.
7 days.
7 days in filing the writ appeal. We have heard Mr. S.S. Mahanti, learned S. Mahanti or S.S. Mahanti?
SS months.
Mr. S.S. Mahanti, learned counsel for the appellant, and Mr. Sisil Kumar Purohit, learned counsel, appearing on behalf of the respondents / opposite parties, considering the period of delay and the explanation offered for the delay. We are satisfied that it would be expedient in the interest of justice to condone the delay in filing the writ appeal. The IA is accordingly, the delay is accordingly condoned. The IA is allowed and disposed of. Copy of the
My lord, I'll file it, my lord, in course of the day.
copy of the writ appeal shall be served on Mr. S.K. Purohit, learned counsel, appearing on behalf of the respondents, and course, Mr. Mahanti undertakes to serve a copy of the writ appeal on Mr. S.K. Purohit, learned counsel for the respondents, appearing for the respondents, list the case on 30/7/2024 for fresh admission.
Well, the only difficulty is that I have filed an IA. They have already filed a contempt against me.
They filed, has it been listed?
No, I'm not quite sure.
Not in the list, madam.
Contempt 54, not here, madam. 542024.
He will not press.
So 1 week, you serve a copy.
I'll just do it, madam, immediately. Grateful, madam.
Don't do that.
Grateful, madam.
37. Very please, your lordship. My lord, as per your lordship. My lord, as per your lordship's order dated 9/7, I filed the detailed affidavit as directed by my lords.
Yes.
I have filed a detailed affidavit by the regional manager as directed by your lordships on 9/7.
Yes.
I've solved also copy on the other side.
Yes.
Though
What
he
does
has
he
not
say?
served the copy of the writ appeal on me.
What does he say?
Pardon,
What does he say?
may I read that? The gist your lordships want to know. The gist is that we have complied from time to time all the directions given by this honorable court. And also the last order we have also complied, but they have filed one interim application which was pending before honorable single judge for adjudication. That's why I have given the detail. Then he has come up in writ appeal against the review order which was passed long
We
back.
understand.
Pardon,
We understand that there is an interlocutory application pending before learned single judge.
Yes,
Therefore,
ma'am.
in our order, we had clearly mentioned that we understand that this appeal is not maintainable prima facie.
Right.
But still, because his the status of his client, we wanted your regional officers and the conduct of the bank manager.
Well, the conduct he has carried out, my lord. That's I have
Not
stated.
carried out, Mr. Mishra, that affidavit, counter affidavit which was filed in the writ application, that has caused all these problems.
No, that
No?
has been reviewed. That
No?
has been reviewed by my lord, the single judge.
Why was it reviewed?
This is an error.
Counter affidavit.
That was
did not.
only one thing was there was an error.
Just a minute. In your counter affidavit, you did not bring to the notice of the court that opposite party number 2 was not the nominee in that account.
No, we have mentioned that the nominee is there. That's why it is difficult for us to proceed further.
Putting out the specific portion. Why we had issued notice. Why we had asked you to file the affidavit. All right.
Yes.
Your counter affidavit. You have filed the counter affidavit. Last time you apologized that it was a mistake, and now
No, it was a mistake. No. I apologize because that was a mistake at the time of filing the counter. We didn't mention.
Our difficulty is that we are not in a position to convince you. All right.
No,
we have failed.
No, that is not it.
Yes.
The problem is that at the time of filing the counter, we have omitted that. That's why error was committed, and that error we have tried to rectify by filing the review. And review was allowed, my lord.
Yes, we
and review
understand.
was allowed. That order was carried out.
Is there any reason to file the review application?
My lord,
Unnecessary because of your.
No, my lord. Sometimes there are errors, my lord. Errors is rectified. That is the law, my lord. That is a provision for rectifying an errors, my lord.
So
that's why the review provision is there in all the laws. That is the review provision. That's why you have filed a review application. Review application will allow only.
We are warning you, Mr. Counsel. You are spoiling your client's case.
I'm sorry.
If you want some action by the court, we will take. You are entering into an argument.
No, my lord. I'm not arguing. I'm convincing your lordship. I'm convincing what was the error. Why that?
The error, we remember, that is why we asked you to file the affidavit.
Your lordship directed me to file an affidavit detailing what steps you are.
Ask your regional manager to be here. It is impossible for us to. And what is your opinion? Where will the money go?
Money will go to the legal heir, my lord.
Give him.
Yes.
Give him.
But the procedure is that I have.
Whatever procedure you have to follow.
The nominee is not signing that is the problem. That's why, before the Honorable Single Judge, that problem arose, and I have pointed out that.
Yes.
That's why the Honorable Court directed that you call the nominee and you make a compromise between the nominee.
No
and
question of compromise. Ask your regional manager to be here.
That was the order, judicial order passed by the Honorable Single Judge also.
We are passing the order.
We are ready to pay the money.
Where is that?
Your Lordship direct.
Where is your affidavit?
We'll pay, but the nominee has to sign the.
The regional manager, SBI Parga, has filed an affidavit in compliance of order passed on 9/7/2024. So stop. Next. It is a peculiar situation has arisen. So stop. Admittedly, the appellant is the legal heir of the deceased, being the widow.
Yes, ma'am.
Legal appellant, comma, is the widow of the deceased account holder is the legal heir. So stop. What is your name?
Akshay Kumar Naik.
Huh?
Akshay Kumar Naik.
What is your client's name?
Subhagini Meher.
Subhagini Meher.
Huh?
Subhagini
Subhagini Meher.
Subhagini Meher.
Subhagini Meher was made nominee of the account. So stop. We are. Huh? He is not the nominee.
No.
You are for the widow.
I am for the widow. I am for the widow.
Sorry. You are for the nominee. So what is the name of the nominee?
Rohit Meher.
Rohit Meher. So why is he not signing the document?
No, Your Lordship. I was requested.
What requested? What will you do with the money?
Are you willing to are you going to sign the papers?
Yes, I was requested for whether she has not responded.
What will she do? You have to go to the bank and sign. What will she do?
In fact, account number also is not my knowledge, Your Lordship.
He will inform you.
Here we go. Who was the nominee? What is the name of the nominee?
Rohit Meher. Rohit Meher.
Rohit Meher.
I think in our annexure, Your Lordship, you can see annexure.
List this matter on so and so, on which date the
Place 12.
nominee. Just a minute. The nominee, comma, the regional manager of the bank, the branch manager of the bank shall be required to be personally present in court. All of you, the nominee will be here. The poor lady, all of you are harassing. Next week.
38.
Date may be fixed. I'll
1 week.
30.
1 week hence.
38.
Or he can come on Friday, on Thursday.
Next Friday.
Thursday. Thursday.
Next
Thursday. Thursday.
Friday.
Ask them to hear on Thursday. To be here on Thursday.
This Thursday or next?
Yes, this Thursday.
Obliged.
Day after.
The demolition matter, I
38.
limited favor people are, so 1 month time may be given. I remove my articles.
Huh?
It is the demolition matter.
Which item?
38. Next item. 38. Next item.
Yes.
He's calling.
Who is going to remove your?
Copy number 1, Tahsildar. He gave note without endorsement. He take the kindly annexure 3 Milord. Now another notice due to car sector, they could not able to take, but now.
So where have you made the construction?
Hello?
Where have you made the construction?
Could not have.
Structural
But my land is adjacent to the land below. They violate that some person is encroached. But that is the reason. My land is the adjacent to the land of the national highway below. So they allege some person, it is extended below.
Extended
So
on
I-
the national highway.
देखिए
We see, Mr. Counsel, we will not give you time. Because it relates to construction of national highway, that is very important. So we decline.
I undertake, I will.
No question of undertaking. Because of your undertaking, the construction of national highway cannot be delayed for a month.
Only one room that is servicing. Only I pray 1 month time may be given. I will remove my belongings.
No.
What that is?
Sorry.
Only 15 days time because there is some material is there. That is only some day because of I remove my belongings.
We will see. The 2 weeks. This matter of 2 weeks. Most of in the meanwhile, the petitioners shall inform.
They are going to remove tomorrow. They are going to remove tomorrow.
2 weeks.
Yes.
Why are they? Why are they going to remove? Who is going to remove?
No, he said, if the lordship see the order of the honorable court, the single judge, honorable single judge stated that his land shall not be touched, and the government land, if any encroachment, that shall be demolished.
Very good.
And that is the order before the
they allege that some person encroached.
Not for.
If you will remove, then it will be broken down. That is the only. I ready to.
So Mahapatra, if some person encroach, what is your problem?
ଯଦି ଟାଣିଦେବେ ଭାଙ୍ଗିଯିବ I will
You
remove
will
my
do it yourself.
ସେଇଥିପାଇଁ ଭାଙ୍ଗିଯିବ ପୁରା ସେଥିପାଇଁ I will remove my
Standing structure will not be affected, which is there on his plot.
No, but he is saying that it will take.
No, 2 weeks. 2 weeks.
I pray tomorrow today may be better because tomorrow they will go to
Is there?
affidavit because the Tahsildar saying that the order is passed, your lordship judgment is there. If an affidavit will be filed, he will
may
take
not
that.
carry.
Item 39.
What
My lord,
Is that let us fit and appeal which?
my lord,
Being shown that it should have been written, right? Nomenclature only, otherwise it's the same thing.
my lord, there is an application, there is an IA file for change of nomenclature from LPA to WM, my lord. As per the SR's objection, we have filed it.
Application has been filed for changing the nomenclature from LPA to WA. This application is allowed. Let the case be renumbered accordingly.
Mr. Dora, it will come up on next Thursday.
My lord, no, not an issue, my lord. My lord. Thank you, my lord.
Renumbered and leave it then. All right.
Thank you.
Contempt matter.
Then you have to move a memo for listing after it is renumbered. Yes.
My lord, my lord.
SL list. Content matter. Item number 1.
The 73 had been mentioned.
Contributors of you.
Content matter. Specialist content matter for 73 points.
Lordship, item perhaps 1 to 6 in progress, Lordship. Right.
Very good.
Right.
Specialist. Yes.
Item 1 to 6.
Yes.
Item number 7.
No,
Item number 8.
Item number 73.
May it please, your lordship. My lord, my unfortunate is your lordship. The petitioner appeared late examination, madam. My lord, the answer sheet I have downloaded from their website. They say download from our website. My answer sheet speaks, my lord. When I compared with the answer sheet, my lord, I have secured 687 marks, my lord, out of 720. But my answer sheet, when they uploaded my answer sheet, it is only 3, your lordship. I gave a mail to their authority that to correct my answer sheet, giving him, my lord, 3 marks, rather to give me 687 marks, my lord. They gave reply, my lord. Lordship, may kindly have a glance to page 23.
I have a small interruption, my lord. I have a
Yes,
small
madam.
interruption. My associate is within present in the court. Today we are filing affidavit. Let the copy of the same be served to the council and he let them go to it.
Lordship,
Thereafter-
on 11/6, I have filed this application. On that day, my lord, since the urgency of the matter, my lord was directed to file the counter by the next date.
Yes.
This is the 3rd date, your lordship.
remember
And the
we have
council
done that.
process is going on from tomorrow.
Lord, and today in the second sub item, they have served the copy of the counter.
All right,
Therefore,
he is
Lord,
filing today.
my lord, my prayer would be the shortest possible date, my lord, subject to your lordship's kind convenience, my lord.
File it. When will you file? Tomorrow?
Tomorrow.
My lord, last time they said,
Give
the
up.
last occasion they said today, and again,
It depends on the officials. to-
Last
Already
occasion,
hard copy is with me. Mr. Gochayat is present in the court. He will hand over the same. I'm sorry, my lord, I'm here.
Give him a copy.
Yes. Is Gochayat is there? You will hand over the copy.
Give him a copy.
Yes.
Huh? Thursday.
Next Thursday.
You want next Thursday?
no,
My lord, I have to file a rejoinder, my lord.
my lord, I would like the matter on this Thursday. my
What
lord.
rejoinder without
There's no
seeing?
rejoinder required, my lord, in my matter.
Yes, my lord, I'm ready on Thursday.
14287. Thursday, my lord, may I have your lordship's indulgence to have it at 2 o'clock, subject to your lordship's convenience? My lord?
Just make a
I will
mention,
make
sir, as they have taken
I will make
the
a
matter.
matter. Deeply obliged. Deeply obliged.
Obliged.
Not Thursday.
Item 177 content matter, your lordship directed to comply the matter. Let it come tomorrow, my lord.
Which matter?
77 item, content matter. Last occasion, your lordship directed.
77. How 70 contempt matters? How contempt matters?
77 serial number 1.
How contempt matter is urgent?
I will take them tomorrow.
No. How is it urgent? That is what we are saying that you are mentioning out of turn.
Your lordship last occasion director, unless it is complied by yesterday, then
Oh, someone is going to retire or something. Someone is going to superannuate.
my lord, that appointment matter, 2023 order, they have not complied. Time and again, they took time, my lord.
That can wait. Appointment, promotion.
Appointment.
That is single bench matter.
A division, read appeal order.
On site only.
That is, my lord, 1866 of 24.
Oh, no.
That is
That is different. This
This
was
is-
the diploma engineer is supposed to.
My lord.
Wait. वो कौन सा matter? That matter to my attention. Single bench. No, that will be taken up today. After this. After rise of the division bench, I'll set single. Not take.
For admission, item number 40.
Item 40 may prefer 1 week after. I have received a counter on 20th May 24. I want to file to respond to it. On 20th May 24, I have received.
If I remember this item you had mentioned for listing and now every date it is being adjourned. This is
The
my-
Konark matter I have mentioned.
No, this matter.
This matter I never mentioned.
No, 40, who is appearing?
My friend is appearing for the
I am
opposite
appearing
party.
for the opposite party.
My friend served a copy of the counter affidavit in the last occasion.
2012.
Yes, ma'am. Any day after 7th of August.
Why?
2012 matter.
My lord, any day.
No, number of times it is.
What is the matter about?
And this matter, And the Commissioner of Endowment has passed three different matters. In all three matters, three orders have been passed. By taking aid to the amended law, which was not there at the time of initiation of the proceeding, that has been taken it. I have already filed my written note. My friend has served a counter copy on 20th May 24 of this month, in the last occasion. I want to respond to it. I have already.
But you had taken time for filing rejoinder.
My lord, on the last occasion, I have.
Last means 1 month ago.
1 month. I have prepared. It
Now
could,
what? Again counter, again rejoinder. Already you have received counter.
counter I have received.
Yes.
I have prayed on the last occasion. I prayed for
Just now.
rejoinder. No, not just now. The last occasion.
See, Mr. You.
One chance.
For you, it may be very casual thing.
No.
But for us, it is very embarrassing.
That's
That we are 2012 matters are pending and we are taking up 24 matters.
My friend.
Why should we take up 24 matters?
My friend has taken time for filing counter last 4-5 occasions. Any date on 7th or 8th.
So we will take up old matters now. On once a week, we will take up old matters.
May I pray, can it be on 7th or 8th?
Thursday. Old matters cannot be ignored like this. And unnecessary is to 2012 you are seeking adjournment. Why didn't we are granting you time, but you pay cost? How much time?
No, my lord. In fact, I have filed my note of submission. I have filed.
All
Since
right.
my friend has given a new
You have to
document.
file a rejoinder. You have to file a rejoinder. Pay fine.
My lord, if your lordship, I am also otherwise ready in this matter.
We are ready. We are also ready.
If your lordship, now this,
Make your submission.
all three matters. Any
Yes.
day, convenient to my lord, 7th or 8th. I also-
Tomorrow. Why 7th or 8th?
Tomorrow.
Tomorrow.
As your lordship.
Yes.
Item 41.
Notice, Nicola. Notice no adjournment shall be granted in old matters.
I may pardon, my lord. Item 41. I'm on behalf of Mr. S.D. Daslan, Senior Counsellor.
Huh?
May be taken up Friday, my lord.
What is this matter about?
I'm challenging the order of the honorable single judge, my lord.
Huh?
We have challenged the order of the honorable single judge where, my lord, the petitioner had prayed for the cancellation of the petrol pump, my lord. It will be taken up on Friday, my lord. Mr. Das will appear in this case.
Letter of intent was issued to me. I am the respondent. Letter of intent was issued to me. They had challenged it, and in the writ petition had succeeded, where the learned single judge had directed the appellant to proceed with the letter of intent issued in favor of me to run the petrol pump, my lord. Now, my lord, what has happened is on 28th September 2022, this honorable court had passed an order allowing the appellant to run the retail outlet through any other ad hoc dealer. As a result, my lord, I am suffering right now. It may be taken up on Friday for final disposal, my lord. I'll be highly obliged.
As requested on behalf of the appellant, this matter on Friday, no, Monday. It is made clear that keeping in mind the nature of dispute, court shall not grant any further adjournment. Yes.
Item 42.
Oh. Tomorrow. We'll file for other American sound.
First item.
I think your lordship will take up other matters tomorrow.
Tomorrow?
All other matters, rest of the matters.
All other matters will be taken up tomorrow. This
also tomorrow. What is that? Passion touchy.
No,
Rest of that.
No.
There is an interim order that should continue.
Item 43.
Tomorrow,
Sorry.
Yes, 42 is tomorrow.
All other matters, I think.
All other matters we are taking up now. I mean, as many as possible.
Item 43.
Yes, deceased. Respondent has filed. Acha, all right.
Respondent has filed, but he has not appeared.
I am for the respondent. So who are you?
I am petitioner in read petition.
Then who has died?
Petitioner is dying. Now government file read petition. Read appeal. Government file read appeal.
Wrong review.
Yes.
Government have filed the substitution.
No, has filed. But who is dead?
Petition respondent is dead.
So for whom have you appeared?
I am
For whom?
on behalf of substitution wife is appear. Jane to.
Have you filed wakalatnama for the wife?
No.
That is why I'm asking, then from who are you appearing?
The file.
File korchandi para?
Madam, unless you file a wakalatnama, you cannot appear.
What is the file the wakalatnama?
See the.
Yes.
Do you have a wakalatnama of the wife?
Yes.
Mr. Khuntia, there's a legal heir certificate which he has filed.
Oh, yes.
So you take steps.
Yes.
Yes. Mr. M.K. Khuntia, learned additional government advocate, prays for 2 weeks' time to take steps for substitution of deceased respondent number 1. List the case. Sorry?
Today file the wakalatnama from her wife. Respondent's wife.
According to the legal heir certificate, how many?
No, this is a pension matter.
Okay.
Legal
Then
heir.
1 week she's giving, you give it 1 week. 1 week time, list the case on 37/2024.
Item 44.
I'm there. So this is a matter, if you kindly appreciate, that government issued a circular in 2020 where they have categorized 5 category of employees of different institutions who are to be given seniority, like the principal cum secretary of a college, basing on their date of birth, seniority on the date of birth. In one category, the date of joining in service. This honorable single judge, in an elaborate judgment, quashed that notification. So petitioner filed a writ application which is akin to the same facts. That was also allowed. And petitioner was allowed to become the principal cum secretary of the college. A review application was filed, a person whose name was recommended on the basis of date of birth. In that review application, a fraudulent document, a manufactured document of the governing body was filed in the review application that was objected, saying that this document is not a genuine document and 2 clauses have been incorporated deliberately to show as if I have been penalized. And the Honorable Single Judge reviewed the judgment, saying that a disciplinary proceeding was there, you have been penalized. A person who once has been penalized should not be considered, and the judgment of this writ application was reviewed and recalled. That is the subject matter for us. Also, glaring on the face of it, that those documents have been
Is there any criminal consequence?
I filed it.
Criminal case? Criminal case you have filed?
I couldn't.
No, you are alleging that some fraudulent document was given.
Yes.
Have you lodged any complaint or
I
anything?
had a counter.
Have you lodged any complaint or FIR?
Complaint I have to file.
Oh, we want to know whether the act of the review petitioner has any criminal consequence. This is what we wanted to know.
Yes, but it is a fraud on the part of the court, on the court. It's fraud on the court.
Did you do anything?
Sir, till now, actually, I am, because my services are strict, therefore I am before your lordship. I will do it, but definitely I will file a complaint.
No. Who is for the other side?
Well, I am for this.
File affidavit.
That's not a fact.
I'll show one
That's
document.
not at all a
I'll
fact.
show
No.
it one document.
There was suppression of fact at the time of disposal of writ petition, which the Honorable Single Judge has taken note of. This appellant before my lords has suppressed material fact before the Honorable Single Judge, got an order, despite there being a proceeding against him, despite there being punishment orders against him, he suppressed all these facts, took a judge order covering the.
File an affidavit.
But I'll file. I'll definitely assist my lords. I'll file affidavit. I'll file those records to assist my lords. Give some time to me, Lord. I'll
1 week.
I'll do that.
1 week. 1 week. As requested by Land Council representing the respondent number 1. There is only one respondent.
I'll also respond on 6, my lord.
Respondent number 6.
Only contesting.
What is this matter on? 2 weeks, correct. 2 weeks. Let the counter affidavit be filed. In the meanwhile, well in advance, upon service a copy thereof on Land Council for the petitioner. So that
Yes, I'll
the post office, if advised, a rejoinder may also make on anything.
Obliged not.